I'm going to ask everybody to switch off their microphones as well as their cameras, although I think the cameras are automatically disabled. But yeah, just the microphones, if those can go off. Thank you. Thanks, colleagues. Let's leave it off. I'm going to switch off the camera. Let me share screen. All right, tell me, can you see the PowerPoint presentation?
Yes, we can.
Yes,
Yes,
we
we
can.
can.
Okay. Okay, colleagues, have you heard of the expression death by PowerPoint? Okay, great. Have you heard of the expression death by PowerPoint?
Yep.
Yeah, okay, well, this is one of those lessons. It's death by PowerPoint, but it's the subject itself, personal injury claims, covers a lot. There's a statute that we're dealing with, which is the Road Accident Fund Act, and that one is a bit of a tricky one. So I needed to put it all into PowerPoint slides so that we make sure that we get through the material and that everybody is understanding and following me. So just to introduce myself, my name is Raheel Ahmed. I'm from UNISA, and I will be presenting for the next 2 days. And I can see this, from what I saw, there was quite a lot of you. So while I'm presenting the screen, I am not able to read the chats. So I think if at least if your microphones are working, I cannot actually see if even the hand goes up. Can somebody just try putting their hand up? Let me see if I can see that on the screen. Let's see if it shows at all. I'm not seeing anything. I literally have to switch screens. Okay. Yes, right. Let me just answer your questions here. So anyway, thank you for putting your hand up. So I think this is not going to work. I need the PowerPoint to explain to you. The slides will be available. As far as I know, I sent it to Sukiswa and she said she would be sending it to you. Apparently, this is also being recording. I see there's a recording going on. So for those that are struggling with load shedding, it will be available for them. So I think the best way to deal with this is, okay, great. Somebody says the slides were sent via email, colleagues. Yeah. Okay. Together with the link. Okay, colleagues, right. So there we go. The slides have been sent. Everything is in order. I think the way we can work is let's just stick to my PowerPoint slide. And as we go, I like it to be interactive. So because it's a difficult subject to grasp, there are sections of the work that we will get through and you might not understand or might need to repeat something or explain it in a different way. So there, I think, because I can't see your hands, I think put your microphone on and then I know you're interrupting me. Or what I'll do is at least at the end of the slides, I'll try and just check with you all if everyone's still following. Is that fine, colleagues? Will that do?
Yeah.
Yes, that's all right.
Yes.
I think at the end of the slides is perhaps a good idea. Just a suggestion.
The end of the slide? Meaning?
No, sorry, I meant after each topic or after every slide.
Yeah, okay. I think that's, yes, that will work, colleagues. And then as we're going along, there is a break where I definitely need to give your mind a break so that we don't confuse you. But other than that, as we're going along, if it's getting very bad and you need a break, a bathroom break, a comfort break, whatever it might be, just let me know as well, because I can rattle on. Okay, let's begin then, colleagues. First of all, personal injury claims is covering quite a number of things. But to start off with, what I wanted to say is that what is contained in these slides is not covering the entire guide, right? It's just I'm focusing on particular aspects or I'm covering certain things that are important for you to grasp. So I will try to, a bulk of it will definitely come out on road accident fund claims because I think that covers most of the material. But there's a nice section there on public liability, on PRASA, unlawful arrest and assault, harm caused by animals, professional negligence. There's a small section on contingency fee agreements, which I'm sure you also cover in another module, ethics, and medical negligence as well. Also, that has been recently added, and that is actually quite short, but you will get the gist of it. By the end of this, you will get the gist of what personal injury claims deals with. The slides have been made available. Oh yes, one important thing is that I don't exactly follow the guide. Sometimes I switch. I might say paragraph 2 and jump to paragraph 4. It's just my own way of dealing with it to make sure that it's easier for you to understand. All right, somebody's speaking there. Microphone on. Who's that? I can't hear you. And I can't see anything in the chat either. Colleagues, anything wrong there? All still following me?
Yes.
Yes, we are.
Okay. So what I'm saying is that, yeah. Okay, let me finish the slide. So I'm saying that I will jump it, but what I will do is wherever I can, I have actually mentioned which paragraphs I'm referring to. Okay. All still following on the same page with me?
Yes, still following.
Okay.
Yeah.
On the same page, Mo.
Okay, great. So now, anyway, I just want to give you a brief introduction. And here, if you see up on the top of the slide there, I say paragraph 1.5. So the law of motor vehicle accidents in general, it's a blend of different areas of law. So we deal one side with the law of delict. That's actually the backbone of road accident fund claims. So the law of delict is really important. Also the law of damages, it's not mentioned in there, but law of damages, obviously, once there's a delict, then we need to know the other section of it. What is the damages, right? Then the law of insurance and socio-economic legislation, because sometimes we are talking about COIDA and COID Act, so those kind of elements come into play. You'll notice that, or if you haven't, or if you aren't already in practice now, you'll figure out that there's never a case that's not complicated. It always involves so many things, and it covers different areas of the law. Continuing though, you'll come across probably the law of contracts, especially with discharges, exclaimers, going on further with public liability as well. Family law is quite an important one as well. That covers locus standi, curators, law between husband and wife. Forensic medicine as well, medical malpractice claims, which we will deal with towards the end. Criminal law, remember, there is nothing that stops you from having concurrent claims. So, for example, even though we are not dealing with criminal law now, you could have a case where somebody was involved with drunken driving and they caused an accident. So you have concurrent claims in the sense that you've got a criminal case going on at the same time. Also, you could be having an RAF claim as well as a separate delictual damages claim. So it doesn't stop a number of claims running concurrently. You will definitely come, yes, depending on obviously the amount and the parties, you'll have to know magistrates court and high court practice as well as attorneys ethics. At this stage though, have you done Mag and High Court or ethics yet? Have you done that yet?
We've only done ethics, not Mag Court and High Court.
Okay. It's not going to impact it too much, but you'll see that some of the rules that we might refer to when you do the High Court and Mag Court practice, it will become a bit more clearer. So obviously at this stage, you might not exactly know how to draft the particulars of claim and all that, but at least you'll get the gist of it, so it won't affect it in any way. Okay, so anyway, I'm now going to deal just with the road accident fund and road accident fund claims. And here there's, I think at this stage, maybe 3 important time periods that you need to know. In the guide, it goes quite far back. To be honest, the one appearing from 1st of May 1989 to 30th of April 1997, the MMA Act, that one, I'd hardly see any cases coming across now. The time period is really past for that. The next one is 1st of May to 1997 to 31 July 2008. That one you might still come across claims in practice. Most of them have been sorted out, but there could be claims with minors that are still ongoing. So the important thing to remember with regard to these dates is the date of the accident or the date of death of the person that everyone is depending on, for example. So those are the time periods that you need to worry about. So most importantly is the date of the accident, right? So if the accident happened, let's just say on 20th of April 2007, then which act are we going to apply? Shout out the answers all at the same time if you like.
Road Accident Fund Act number 56 of 1996.
Yeah. So anyway, now this Road Accident Fund Act number 56 of 1996. This is actually the current legislation that is, this is the act that we're still following now. It's just that it was amended, right? And it was amended by the Road Accident Fund Amendment Act 19 of 2005. So basically, accidents that happened after the 1st of August 2008, there was some very drastic changes that happened. And so look at the date of the accident. Anything from 1st of August 2008 onwards, we're going to apply everything to do with the amendments. So in the guide also, just to differentiate between the two, remember now till today, we still call it the Road Accident Fund Act number 56 of 1996. But to explain to you the different things that apply to those timeframes, in your guide, we refer to the preceding legislation, which means before the amendments, and then we refer to the current legislation. That means basically everything after the amendments. That's a very important thing. Are you following that?
Yes.
Okay.
Yes, we're following.
Right. And then this Road Accident Fund Act number 56 of 1996. This is just actually an interim measure in the meantime, because they are hoping in future to implement, well, they've started actually, they've drafted legislation. It's a draft. It's Road Accident Fund Benefit Scheme. So that is future legislation, and that is to bring it more in line with other acts, sort of like COIDA or COID Act, and that one I'll also discuss closer towards the time, later on in the lecture at least. So basically what happens is with the law of delict and law of damages, right? Remember there you are dealing with the common law. Okay, somebody's mic is on there. Right, Mike, thank you. Okay, so Mike is back on again. All right, so remember the Road Accident Fund Act is a statute. So it regulates motor vehicle accidents in South Africa. So what happens now is that instead of having the common law wrongdoer, the RAF itself steps into the shoes of the wrongdoer driver and takes the place of then compensating the injured party, right? So the claim of compensation generally lies against the RAF only. There are exceptions, mainly one very big exception. I don't want to mention it right now because it could confuse you, but I'll explain to you and then you'll understand it. So what I'm going to do is focus really more on the preceding legislation, because if you're going to go into practice, that's what you're going to really come across now. I mean, sorry, not the preceding, the current legislation. The preceding legislation, I will deal with it briefly right in the beginning now so that we get it out of the way. And then the rest of the lecture will be focusing on the current legislation. And then towards the end, I'll deal with the future legislation, or at least forthcoming. Okay, still following me? Just switch this off.
Yeah.
Sorry.
Yes.
Okay.
Yes.
Okay. Right now, this statute, it's got a number. If you look in your guide, I don't know exactly which page it's on, but it's definitely in your guide. The whole statute is there, right? The legislation is there. It's broken up into different sections like all acts. So section 18, so the important ones are section 18, section 17, section 21, section 20, but some of those are really important. So that's what I want to focus on, because that deals mainly with liability. the limitation of liability, and then also exclusion. Remember, limitation deals with you limiting liability, but not totally excluding it. Whereas exclusions in section 19, that means it's a total exclusion. It means the Road Accident Fund Act doesn't even apply. So I want to talk to you now about the preceding legislations. I need to put my phone on silent, colleagues. Just give me a second. A lot going on there. There we go. All right. So I want to deal with section 18 of the preceding legislation. Remember now, what is the preceding legislation? Tell me the date again. Accidents that happened before what date? I need to know if you understand.
2008.
But yeah, so everything before the 1st of August 2008. Yeah. So what happened was the preceding legislation, section 18, there were limitations that applied. And one of the main one was regarding passengers, right? That's passengers, and it's mentioned there in your paragraph 2 of your guide. So there, what happened was, first of all, you had to understand whether somebody was a passenger. So even if, for example, you just had your foot stepping onto the step of the bus, that would be considered that you are a passenger because you had the intention, number one, and you were entering the vehicle, right? So in that instance, you would be considered as passenger. Let's just say you had one foot on the ground off the bus and one foot still on the bus, and an accident happened or you got injured. There again, you'd still be considered a passenger. So there again, alighting from the motor vehicle and intention played a role. You come across very tricky situations. Believe me, there's no black and white. So the golden rule was, right? Again, we're talking about preceding legislation. So, colleagues, somebody's got their mic on. I think they're having a bit of lunch, supper there. Please switch the mic. Okay. So anyway, section 18, the important rule was that that limitation of section 18 only applied if it was a single motor vehicle accident. And when I'm talking about single motor vehicle, I mean like this vehicle went into the tree, a lamppost, or traffic lights, for example, right? Would just veered off the road into a wall. That is a single motor vehicle accident because there's no other motor vehicle involved, right? So the limitation, remember, applied only to single motor vehicle accidents, right? And the driver must be the sole cause of the accident, okay? So it can't be a situation where, let's just say there's a pedestrian on the street and the pedestrian is walking across where he's not supposed to, for example. Let's just say it's even a highway, the pedestrian's walking across and an accident happens. In that instance, you cannot say the driver is the sole cause of the accident because yes, he's negligent, but he's not 100% negligent, right? Why is that? Why would I say that? Tell me.
Because of the
Prof,
because of the pedestrian walking on the highway.
Yeah, but why?
It's not a single driver.
The obligation to look before they cross over the road.
Okay, so basically, yes, you're all on the right track there. So basically, there will be negligence on the part of the pedestrian, right? So that means that the motor vehicle driver is not the sole cause of the accident. He's not 100% negligent because there's some negligence that's attributed to the pedestrian, right? So this limitation didn't apply if there was another person or another vehicle involved, basically, right? And the limitation was if you get injured in this circumstance, single motor vehicle, where the driver was the sole cause, then your claim would be limited to 25,000 Rand. It was just that, that's it, capped at that, 25,000 Rand, finished and clear, right? So an example would be like, let's just say I am going with Tiffany to work in the car. Tiffany's the driver, I'm the passenger, and we're just going to Spar to get something from the shops. And in that, she loses control of a motor vehicle and she crashes into a tree. So that's a sort of a scenario where the limitation would have applied. Are you following me?
yes.
Yes.
Yes,
Okay.
we are.
Okay,
we
great.
are.
Right. So
Yes.
remember we spoke about the pedestrian. So if there were two motor vehicles involved, then that limitation can't apply because it's possible that there is most likely negligence from the other driver as well. It's very rare in cases where you get a driver solely 100% negligence. It applies where the person skipped a red robot or something, because there's always duties on drivers, right? So if there was two motor vehicles involved, and if the passenger can even prove 1% negligence against another driver, then the limitation would not apply. Do you understand? That's exactly what we said about the pedestrian and when there's two motor vehicles involved. Yeah? Following?
No, can you please repeat that again?
Okay, so the Section 18 limitation, the preceding legislation, any accident that happened now before the 1st of August 2008, if you were in a motor vehicle accident where there was two cars involved, or your driver wasn't solely negligent, 100% negligent, then the limitation wouldn't apply, which means that that 25,000 Rand cap is not going to apply to you. Do you understand?
Yes, thank you.
Okay, great. Are you sure I haven't lost anyone yet?
No, we are fine.
All
No,
right.
we're following.
Okay. So now, Section 18, subsection 1A, Roman
question,
numerals 1 to 4. Yeah?
Hello?
Yes, go for it.
Yeah, you are saying in this instance, if the driver proves that the other driver is negligent,
Mm-hmm.
then the limitation will not apply.
Yes. So
Is it a similar?
25,000 Rand cap won't apply.
Yes. Is it a similar instance in a case where part of the example that you gave of a pedestrian, where a pedestrian also contribute to the,
Yes.
so the
So if
limitation
there's a
doesn't apply as well.
yes, it doesn't apply.
Or
So, yes. So now that
I was
applies with
confusing it.
yes, no, you got it. You exactly right. You're exactly right. So the limitation applies in that sense. Yes, you are perfectly correct. And remember that was
All right, thank you.
accidents before 1st August 2008 only, right? Remember, we must look at the date of the accident. Yeah?
Yes.
Okay. Now,
Thank
the
you.
Section 18, there was a number of passengers. There was a passenger for reward. That's a paying passenger, somebody basically going to a taxi. A passenger conveyed in the course of the owner's business. Passengers conveyed in the course of their employment, where those passengers are not subject to the COID Act. And then passengers who were conveyed as part of a lift club, right? So it applied to all those classes of passengers in subsection A. Then subsection B, it also applied to the social passengers. So remember me and Tiffany, we just friends, we went to Spa.
Sorry,
right?
sorry, Prof.
Yeah.
I've got a question. Which passengers are not covered by QUADA?
Basically the ones that are in employment and COIDA doesn't apply. I can't exactly think of an example though. Maybe just where basically you haven't registered with COIDA yet, etc. So yeah, it kind of covered most passengers, if you could say. In essence, it covered really all passengers. So they tried to limit the amount of money they could pay, but remember it only applied in single motor vehicle accidents and where the driver was solely negligent. But those were the types of passengers. So it literally, you could say, applied to everybody, right?
Okay, Prof.
Okay. And then, right. Yeah.
Could it perhaps be passengers not subject to QUADA? Could that be maybe subcontractors? Say, for example, an engineer driving to site.
Yeah.
All right.
That's perfect. Yeah, that's a good example. Thank you. Right now, what happened was in 2011, we had Mvumvu and others versus Minister of Transport. Now, in this really important case, they found Section 1A and subsection B to be unconstitutional in this case. It was a constitutional court case, right? And there the Constitutional Court ruled that these limitations are unconstitutional. So what happened was in that actual judgment, they said provide further legislation, and from that there was a Road Accident Fund Transitional Provision Act. So this is all in paragraph 2. It's very lengthy. I'm trying to break it down as simple for you as possible. And at the same time, I don't want to give you too much detail because like actually right now, it's not even, you're not even going to come across it much in practice. But the thing is that you do need to know it. As long as you always remember when you practice, remember, look at the date of the accident and then remember what applies. So on the 13th of February, the Road Accident Fund Transitional Provisions Act, it came into operation, and that was from that government gazette. And in terms of this act, what happened was at the time where there was a case going on that hadn't been finalized yet or judgment wasn't handed down. So if there was still an ongoing case, the claimant had an option. He could elect to state, okay, I want to go and follow the Road Accident Fund Act prior to the amendments. Or in other words, he could say, I want to stick to the 25,000 Rand limitation, or I want to go according to the amendments. Now, the amendments, you're going to learn about it soon. Basically, the amendments didn't limit passengers. So there's no cap on the passengers. So that was the amendment. So if you were a person in that position, you would obviously want to opt for the amendments because then there's no cap for you. Do you understand? Yeah? Following, not following? Tell me.
Yes, we understand.
We
All
are
right.
following, ma'am.
Following.
Okay. Please don't get irritated
Sorry,
with me
ma'am.
because I can't see your faces and I'm looking at my own screen. I got to check in with you all the time. Yes, somebody was speaking.
Yes. Why does it say now a private claimant can either claim RAF Act 1996 or
Or
the
according to
claim
the amendments, yeah.
RAF amendment?
Yes.
Because
So,
especially that one, section 18(1)(a)(b) have been declared unconstitutional.
yeah. So basically, it was declared unconstitutional, but they said that there was legislation that came out. So that Transitional Provisions Act gave them the option. And I'm going to explain to you why the option was applicable, right? So they had the option to state, let's go according to the old cap or no cap, basically. So they gave them the option in the act and they had to actually do an election. And that was done via filling in a form and they had to do it. And it only applied to anything, remember, that wasn't settled yet. If I can explain, so some of them, for example, had to follow the old act because if you were a claimant, right, do you know the difference, first of all, between special and general damages, colleagues, from law of damages? You remember and delict. What is the difference between special and general damages? Anyone tell me?
Special is for the money.
Yeah.
General damages is for non-pecuniary.
Perfect. Yes. So general damages, special damages, everything that can be easily quantified in money. And we're going to explain that later on. And then general damages is basically for pain and suffering, loss of amenities, all those kind of things. There's a lot of heads that fall under general damages as well. So anyway, what happened was, if I go back on the slide there, right? If we look at these passengers, they were limited to 25,000 Rand special and general, right? So classes Roman numeral 1 to 4, they were limited to 25,000 special and general. Do you understand that? So if they had, let's just say, special damages and general, the total they could claim was 25, right? But the passengers, the social or gratuitous passengers, that's me and Tiffany, I would be limited to only special damages. So I can't claim for pain and suffering, etc., etc. It had to be my hospital expenses, for example. Okay, so that was what applied. Remember, Mvumvu said this is unconstitutional, but there was an act that came out says we're giving you an option to apply which one you want to follow. And then they came out with further limitations, if I could say, in the Transitional Provisions Act. So in this act, right, they said if you want to claim general damages, now that's your pain and suffering, emotional shock, etc., you can only claim it if your damages were serious. Okay, now later on you'll understand what serious means because they have a very specific meaning of what serious means. But basically serious means like you've lost both your legs or you've lost both your arms. You're a quadriplegic or a paraplegic basically, or you've lost a body function now, your kidney is not functioning or something. So for them, that was serious, but I'm going to explain that later on so you won't get confused about that. So the claimant intending to claim general damages above the 25,000, right? They had to also ensure that they filled in this RAF form. It's also done there by the doctor. And there was a specific deadline. They said this must be submitted before midnight on the 12th of February 2015. So again, now colleagues, this time has passed. We're in 2023. But I have to just explain this to you in case you've got something still going out there in practice. And then the claimant was also expected to notify it on a prescribed form. They also had to explain if there was compensation that they had received from any other parties, whether it was from the drivers, the owner, any amounts from the COID Act or the Defence Act or any other act of Parliament, basically. So what happens with any government legislation, you cannot claim, you cannot do this double claiming. So in other words, you cannot be compensated twice for the same thing from the government. So if you're claiming some money from the COID Act, then you cannot claim that exact same kind of injury or harm from the RAF Act. So the RAF would say, right, on the form, tell me what other monies you received. And then we will make sure that we pay you after whatever COID Act has given, etc., whatever the compensation commissioner awarded. So that was basically what happened. Before I move on to the next slide, are you still with me?
Yes, we're following.
Yes, ma'am.
Okay, great. Now, to complicate things even further, remember I told you section 18 was about limitations, and then section 19 is about exclusion. So one of the things in the preceding legislation, which I want to tell you about now, so that we get over with it, there was a limit, there was an exclusion, right, that applied to the member of a household. Now, it was a very specific relationship. So in other words, member of the household or liable for maintenance. Here we are talking about instances, I'm in the car, I am one of the working parties in my home, and my daughter's traveling with me. So let's just say my daughter and I, we have an accident. So my daughter, because I was the driver and the cause of the accident, she could not claim from the road accident fund at all, right? And then we can go vice versa. We can say, let's just say my daughter's now driving. She's got a license. She's driving me. And I'm in the car with her, and also an accident happens. She's driving, but she causes the accident. So in those reverse situations, that was basically the member of the household scenario. So that's section 9B2 applied to that. And there you were excluded. In other words, you couldn't even claim from the road accident fund. Finished. My son can't claim. I can't claim because my daughter drove, basically, right? But then there was another important case, Vanessa de Silva versus RAF and the Minister of Transport. And that one, they found that section 19B subsection 2 also invalid and inconsistent with the Constitution. So those are just things that applied, and now you know that basically they don't apply, right? Confusion ended. Yeah? Are you following me still?
Yes, we are.
Yes,
Yes,
All
we
right.
are.
Okay. So we are now done with the preceding legislation. Yeah. Okay, great. So we're done with the preceding legislation. You just need to know it, that I don't know, in case you come across things that, these certain things applied. But that was the story then. And now we are going to deal with the current legislation. So in other words, everything with the amendments, everything where the accident happened after 1st of August 2008. So another important section now I want to deal with is section 17. And this is one of the main sections because it basically sets out the requirements. It's actually a very short section. It's like a, paragraph or so, but it contains a lot of requirements in there that we need to go through. So first of all, there were two types of claims, right? You either had an identified claim or an unidentified claim. So the identified claim, that falls under section 17, subsection A. The unidentified claim, or what we call in practice also hit and run claims, that falls under section 17, subsection B. So two different types of claims, right? Identified, unidentified. Now I want to go along with the requirements for all of the claims, basically for any claim that anyone wants to make against the Road Accident Fund. These are the requirements. I'm going to start with the first one. First of all, before I move on, you're all still following me?
Yes.
Yes.
Yes, we're following.
Yes, ma'am.
Yeah. Did somebody want to ask a question, or did you say following? Okay, following.
No
All right.
questions at all.
All right, so now with the requirements, the first one is the claimant must be a third party. Now, third party is not a simple thing. It's also broken down into two different types of third parties. So you either get a person that was personally injured. So this was me with Tiffany. I was personally injured in that motor vehicle accident, right? So I'm a third party because I was personally injured. Then the second type of third party you had was someone that suffered loss because of injury or death of the breadwinner. So let's just pretend I am the breadwinner of my family, and God forbid, I'm just saying hypothetically, I die. Or let's just say I'm injured and I'm in a coma now. In that scenario there, my dependents, I've got 3 children, all 3 of them were relying on me because I'm paying for their fees, etc., etc. Now they've sustained loss from all of that, from me looking after them because I was involved in the accident. So do you understand there's 2 different types of third parties? You get the ones personally involved and those that suffer loss because of the injury or death of a breadwinner. Do you understand that?
Yes, they are
Yes, we
dependent.
do.
Okay. Yeah.
Yes.
Okay, great. Now, the second requirement is conduct, right? Here you're going to have to dig deep in your brain and remember the law of delict. Conduct, first of all, in the law of delict, conduct composes of 2 things. It's either an omission, right? A failure to do something or forgetting to do something, and a commission, which is actually a positive act. Now, in the act itself, it has its own idea of what is conduct. So according to the act, it's either the driving of a motor vehicle or any other unlawful conduct. So it breaks it down into 2, either driving or other unlawful conduct, right? And now here, it's not so simple. We think of driving as, okay, I'm actually in the car, I'm driving, but the term driving has extended meanings. So in section 20 of the Act, if you look through it whenever you can, you'll see, go through it. But there it actually extends the meaning of driving to include a number of things. For example, it includes pulling or pushing of a motor vehicle by hand, right? It could be by a donkey or a horse, for example, or a car is actually, let's just say I've parked a car on a hill and I didn't realize my handbrake wasn't up. I left my car, I get out of my car and the car rolls down the hill. That is actually still considered driving. So it's not such a simplified meaning, driving. In terms of the act, it's extended. There's those presumptions in section 20. It extends the meaning of driving. I see somebody had a question.
Yes, ma'am. I wanted to ask, in a situation whereby a person gets involved in an accident, but it's not a motor vehicle, let's say it's a horse cart, and they were on the road, is it considered one of those, or it doesn't count?
So it definitely can. So just now we're going to look at what is considered a motor vehicle, right? We're going to come across that just now. Yeah, but a good question. At least your brain is working and I am glad that you're thinking. Great. So anyway, you're following me. Yeah.
Actually, it's one of the things I came across in somewhere, and then what happened is that person was never paid because they said it was not a car,
motor vehicle,
with an engine.
Yeah. No, you're going to understand it just now. Just now you're going to understand it. Okay, so for now, we're just saying it could have been because we're going to look at what qualifies as a motor vehicle. And it's also not cast in stone. But most of the time, they like to give a liberal approach. But anyway, so there's the term driving. And then the other thing is an other unlawful act. So here, for example, there were some cases. Some of them are general accident versus SEPO. There was Wells versus Shield. And there's a kind of number of them as well. It's mentioned in your guide, I think paragraph 5.4.3, you'll come across that. So there it includes a motor vehicle actually skidding on diesel that was spilt on the road, right? So it's not the motor vehicle itself, but because it came across, the tires went onto the spilt diesel, it slid and skidded, and then it collided with another motor vehicle. So that is also considered an other unlawful act. There even was one case of allowing a drunk person to travel in the back of a lorry, or another instance, another good example is where a spare wheel dislodged from one vehicle veered onto the road, the other vehicle then swerves, and the accident happens. So that is also considered an other unlawful act. So there's two different things that apply there, either driving, where the meaning is extended, and other unlawful act. Still following me?
Yeah, sorry, Prof, I've got a question.
Yeah.
Yeah, in terms of the spilling of the diesel, if who is going to be blamed? The person who spilled the diesel or the person who skidded over the diesel?
Okay, so a nice question. You tell me what would you think is going to be liable here? What do you think? Anything, give it a go.
Surely the person who spilled the diesel.
Okay, but at the end of the day, let's just say I was a passenger in one of those cars and I'm claiming, who am I claiming against at the end of the day?
The ref, because they step into the shoes of the wrongdoer.
That's right.
No,
So, yes. Now remember, when you're going to have a police investigation and the SAPS, they fill in their forms and they've got an MVA number, and they're going to take affidavits and photographs and statements, etc. They're going to have the whole story of all the drivers. So actually, there can be negligence from a number of vehicles, maybe one or two, depending. But at the end of the day, it's still a road accident fund. Here is the important thing is the claimant who's claiming from the road accident fund. He's stepping into the shoes of the wrongdoer driver, the person that spilled the fuel, and the other one as well. So they can be both involved. Both of them, their details will be on there. And then obviously with a passenger claim, most of the time the fund will concede liability or whatever the case may be. Not always, but yeah, sometimes. So at the end of the day, the road accident fund is the liable person. That's a really important thing, but I see that you are following, right?
Hello, Professor.
Yeah.
In terms of potholes.
Yeah, okay, potholes is with the municipality, unfortunately. But there is a public liability which we deal with probably tomorrow. And I think one of the questions I do give you actually is about potholes. But yeah, potholes is the municipality mainly.
So even the
what paragraph are you, please?
On this one here, I think I'm still on 5.4.3 or 5.2 basically. Yeah. Yeah.
5.4.
Yeah, somewhere 5.4. Let's just go with 5.4. But that is the section dealing with the main requirements. Yeah.
Sorry for clarification.
Sorry.
The instance whereby there can be joint liability upon the wrongdoer, whereby the wrongdoer can't be determined.
Yeah, there can definitely be joint liability, but that is a question that is dealing with the negligence of the actual driver, joint liability, civil liability. So basically all the principles that apply in the law of delict, they are applicable. That is the backbone for road accident fund claims. We have to apply that common law still. Yeah, you still following?
Yeah.
Okay, great, colleagues. Now, still continuing on section 17, right? Here, remember the lady asked me about the motor vehicle. So section 1, first of all, defines the motor car, and it says it's a motor vehicle designated or adapted to convey not more than 10 people. And this includes the driver, and it includes a trailer, a caravan, agricultural or implement designed or adapted to be drawn by a motor vehicle. So in the Act, section 1 specifically defines motor car, number 1, right? Then from that, you can gather as well how the concept of a motor vehicle is involved. But there was a case as well. It was RAF versus Mbele, where they nicely. So before this case even came out, we were already teaching our students that there are 3 essential elements. And these are the 3, but then Mbele came, this case then solidified these are basically the essential elements, right? So when you're looking at whether a car or a motor vehicle actually qualifies as a motor vehicle, in order for you to claim from the RAF, it's got to have these 3 things. So first of all is the propulsion test. How is the car propelled? Is it by petrol, diesel, etc., or is it electric, right? So how it has to be propelled by something. Then the design test, okay? And this here, we're looking at it objectively, not the subjective car manufacturer that made it, but objectively viewed. Was the vehicle designed for general use on a road, right? And there they go into a little bit more detail. And they also in case law, they mentioned it. It's also in your guide. And they have these questions. For example, does it have a hooter? Does it have a speedometer? Does it have indicators? Does it have headlights, right? So that falls under general design test. And then the third thing was the concept of road. Now, the concept of road is a very wide concept. They get tested in the courts often.
Sorry, Prof.
Yeah.
Yeah, if I may ask, so does the definition exclude the metro rail trains?
Yeah. No, definitely it excludes the trains. So there it's probably PRASA, or if it's how train, but it definitely excludes trains. Yeah. So it's just motor vehicles on the road, right? And then the concept of road is quite the courts interpret it very liberally, and they basically said it's a place that links 2 places with each other. So it's a very liberal interpretation. And then here's some examples, right? So,
Prof, can I check something quickly?
Yeah.
We have things like these cars that people use for sports. I just want to check. Let's say, for instance, we have a racing competition here in South Africa, and then an accident happens. I'm looking at it in terms of the second requirement, which says it was designed for road use. Will that be part, or is it excluded?
So it can be part, right? But there was a case, I can't remember the name, but this midget racing car, that was actually, they said, no, it's not a car. But I think some vehicles can be considered, but it seems like the race cars fell under this midget car racing. But the thing is, you never know. You have to keep checking cases because every year or 2 years they come out with a new thing. So for example, right, a forklift, a ride-on lawnmower. Just imagine this, a ride-on lawnmower is not considered a vehicle. The racing car, not a vehicle. Then they said a go-kart and self-propelled vehicle designed to provide a power to a jet, they were found not to be motor vehicles. But then, a reach stacker. Do you colleagues know what a reach stacker is? It's one of these things, it's sort of like it carries containers, basically there on the harbor side. That one was recently considered a motor vehicle. The Caterpillar truck was considered a motor vehicle, a pneumatic tire roller was, and then the golf cart, but the 6-seater golf cart was considered a motor vehicle, and a quad motorcycle that was used in a park was considered a motor vehicle. So it's not like the courts are totally 100% sure of what qualifies and not. They do look at those 3 elements most of the time. Most of the time you'll get it right, but there will definitely be cases where you'll come across something and you need to test whether it's a motor vehicle. So the RAF might come across and say, sorry, we're not going to go ahead with your claim because you were not involved in a motor vehicle accident with a motor vehicle, basically. And then that'll go to court. And then the question will be, is this car a car? And then you look at previous case law. So if you have come across a vehicle that is listed there on those cases, then you know, okay, it qualifies or it doesn't qualify. Yeah, but it's not cut and dry. It's sometimes arbitrary.
Can I just interject?
Yeah.
Just with regard to the question that was posed earlier,
yeah,
regarding a train, and you referred to the Gau train.
Yeah.
In terms of its propulsion, isn't it propelled by electricity?
Yeah.
Which forms part of those requirements.
Yeah, so it will basically qualify for propulsion, but probably not the design because it's not meant to be used on a road. Yeah, and also the road concept.
Can I ask something? Say if you're not uncertain, would they look at what was the purpose of the car being used at the time of the accident? Would they look at purpose?
Yeah, so the design and purpose is the same thing. What was it built for? What was this vehicle built for? Was it like, for example, something that was meant to travel on the road, to carry vehicles, for example? So they do look at that. So I see in a lot of the cases, they look at, was it actually meant to be on the road most of the time? Yeah, that seems to be the main question when it comes to vehicles, because we never have a problem with a propulsion test. The concept of road hardly becomes an issue. The biggest one is always a design test.
On the road issue, can I just ask before you proceed, on the road issue, the golf cart and the quad motorbikes, because most of the time they are not in the right in the public road.
Yeah.
So does it have limitations, the road use? Yeah, because some they are
Very
being
liberal. It's extremely liberal. So they just says it's a place that links two places. So it will probably qualify. They're very liberal when it comes to the road.
So inside maybe a resort, it's not gonna be qualified as a road.
So yeah, there has been a case where they found in a parking lot of like a Pick n Pay and a church. They said that was a road. That qualified as a road. So they have a very, very liberal approach on the road. It can even cover gravel roads, dust roads, mud roads even. So yeah. So anyway, that is a liberal interpretation. And there again, we've got to just look at cases. So if you come across something where you're not sure, check the cases, see what qualifies or doesn't qualify. But definitely the Road Accident Fund will tell you whether they say it's a motor vehicle or not. There was, yeah.
What if
what about the solar cars?
Sorry, I can't hear you. The failure of what?
The solar cars.
Yeah, it might qualify. I don't know. Design and propulsion, electricity
yes,
or gas.
Propelled by electricity, so it will qualify.
Yeah. Okay, but we're gonna keep testing. I think they will keep testing it in the courts. So the main thing is, I don't know if you guys get legal brief often, but legal brief is really good. It keeps telling us, like it's news almost every day. But there you'll know when there's a new case that came up where they said, oh, this now qualifies as a motor vehicle, because people were shocked when the golf cart was qualified as a motor vehicle and the quad motorcycle. So they keep testing it. But generally, if I can say, the courts like to have a liberal interpretation because they want to make sure that they cover the road accident victims all the time. So generally, the courts are very liberal most of the time, right? But every now and again in my slides, I mentioned an article that I might have written So this one was on the quad motorcycle, but it's there. It's not compulsory for you to read. It's literally further reading if you like.
Ma'am, can I please ask?
Maybe just to check, where do buses fall?
We do?
In case we get an accident in a bus, what happens? Because I think it conveys more than 10 people.
Yeah, so then then it doesn't qualify. So remember there it says the vehicle can't be more than 10. It mustn't have basically more than 10. Yeah, so then it's not a road accident fund claim involved, right?
What
happens
level
in-
that?
More than 10.
Sorry?
Yeah, maybe just to throw a question there. Let's say we're dealing with a situation where one is a vehicle which carries less than 10% people, and then the other one is a bus, and then in both cases people get fatally injured or others even their lives.
Yeah,
So what
so
happens?
the one, yeah, so there will be claims for it. There will definitely be claims for those people that were traveling in those vehicles that qualifies, and they have a claim, especially the claim will continue, basically. Yeah,
But
do you see how it's
so-
never black and white actually?
So,
But
So
yes.
what happens with these cases where some buses have 10, 15 passengers?
You mean to say, are you trying to say that in a case where it's supposed to carry 10, but they're carrying more than 10?
No, I'm saying buses that are designed to carry 15 passengers, and they do carry 15 passengers, and an accident happens.
So what happens is it depends on who was negligent, right? If the other driver is negligent, that's not qualifying as a motor vehicle, and you send this claim to the road accident fund, they will be very quick to say to you that no, it didn't qualify as a motor vehicle. Your claim is not against us. So remember, anything that doesn't if it's not against the road accident fund, doesn't mean it's the end of the story. Then we just fall back on common law, basically, right? And there will be.
Are we
we
saying
fall
even
back
taxis
on
don't qualify?
common law. So taxis qualify. They do qualify. Most of the accidents are actually without taxis. So the taxis qualify. But remember, if it's not with the road accident fund, then it's with common law. Important thing to remember is the Road Accident Fund Act has its own prescription time frames within which to do things, right? To lodge your claims. They have their own time frames. But common law, then we follow the Prescription Act, so there it's 3 years. So if something is, if you don't qualify in the road accident fund claim, you go fall back on common law. Do you understand that? Okay. Okay, great.
Maybe just hold on there, Prof. Yeah, maybe explain that point a little bit more, because what I noted, even in terms of your introduction, is that you have highlighted a number of areas where personal injury claims can be done. Like, for instance, injuries based on road accidents, on public entities like roads and ESCOM, municipalities and ESCOM and other things, PRASA, and all of that. So if there is a claim that can be made, for instance, in relation to what is this? Any transporting system that carries more than 10, why are we not? Are there no specific rules that apply to that, so that when we look at personal injuries, we would know that in an event of road accidents, as it said, that it should be a vehicle that carries less than 10, we use the Road Accident Act, and that, but if it's more, we use this act. If it's others, something like that.
So that's the fun part about being a legal practitioner, is you have to know a lot of different acts, right? So besides the Road Accident Fund Act, you've got to know if you're claiming against an organ of state, there's specific rules that apply there. there's again, anything against an organ of state, there is specific prescription periods that apply as well. I think you've got to give notice within 6 months, otherwise you're in trouble. And then if there is no statute that applies, let's put it this way, if there's no statute that applies and you're not claiming from a government entity or anything, then you always fall back on common law. So common law is your fail-safe or your fallback. I think important thing to remember is prescription. That is really important. Like if you get a claim, make sure number one, it's not prescribed, first of all, like 2 or 3 year period hasn't passed or whatever. But yeah, fall back if there's a statute that doesn't apply, it's the common law, law of delict, law of damages claim, etc. Yeah, following.
Prof, please, there's something I want to touch on. It's not like to take us back, because I'm aware there are some taxis specifically that carries more than 15 people.
Mm.
And most of these accidents.
Yeah. So in other words, if it was designed, if the vehicle was designed for more than 10 people, for example, then the road accident fund, when you lodge the claim, they're going to come back to you and state, but it's not within our purview. It doesn't qualify, basically. So that's what I'm saying is then you fall back on common law. You're following?
No.
No.
If we fall back on common law, do we then make a claim from the driver or?
Yeah, from the wrongdoer driver.
Oh, okay.
You fall
Okay,
back
Prof, in the instance of the agricultural sector, you'll find out that there are these trucks which are used to carry goods, but instead they are carrying workers. So in the event of an accident, whom do we claim against? Do we claim against the driver of that truck or against the employer?
So remember, if you fall back on common law, what would you do? You would sue who? How many people would you sue there? You would sue the driver, number one, right?
And the company.
And the company. The driver probably doesn't have money. The company has the deeper pocket, but they can be jointly and severally liable.
Sorry, Prof. Can I assist there with the issue of
That's vicarious liability.
Yeah, sorry, I didn't get that.
I'm saying, can I assist with the issue of motor car with 10 passengers? The Act actually makes provision for, or in the definition, a motor car goes up to 10 in terms of passengers. And then anything beyond 10 is classified as a motor vehicle. I think that's where the confusion stems from.
Oh, okay. Yeah, so anyway, basically it covers, okay, so it's Road Accident Fund Act will cover those claims. What did you say? Is that in the actual definition?
Yeah, that's correct. It's in the definition. Motor car specifically refers to any motor vehicle that carries up to 10. As soon as the passengers are more than 10, then it's a motor vehicle. It's actually in the definitions.
Yeah. Okay. All right. So anyway, it is covering motor vehicles. They say try not to convey more than 10, but then they do say, I see what you say. It includes trailers, caravans. Yeah, I see what you say. Okay. Yeah. Okay. Anyway, let's not get too hung up on that confusion. But basically, put it this way: if a vehicle doesn't qualify as a motor vehicle, then the Road Accident Fund will state so, and you will fall back on common law.
Hello.
Yeah.
I just want to confirm something. Yeah. There's a case, the Broglio case.
Yeah.
Where the ruling a victory for taxi passengers.
Yeah.
Where they could claim 25,000 rand for injuries before, I think 2008 from the previous legislation.
Yeah.
But pay more than 10 passengers. I mean less than 10 passengers. It just says passengers in a taxi.
Yeah. no, that is common. So I think 90% of the accidents are most of the time with taxis. Yeah. So remember, yeah, that was taxis. They qualified as motor vehicles, and they used to be limited 25, no longer.
Yeah, but what I'm saying is, my point is, so the 10 passenger limit doesn't come into.
Yeah. No, it qualified as a motor vehicle. Yeah. I think let's not get too hung up. Yeah. No, I get what you're saying. So this definition is actually from the Act itself, but it looks like as if it's not gonna be. We're not gonna get hung up on the actual numbers, but definitely taxis for sure qualified. Many things happen to taxis. So yeah, is that correct? Are you still fine, colleagues? Still okay?
No, I'm fine.
Okay.
Yes, ma'am.
Okay, all fine. Can I continue? Can I continue?
Yes.
Okay, right. So the next requirement now is conduct, right? We did speak about the conduct a little bit earlier. The conduct itself must be by the owner or driver of the motor vehicle. And it can even apply where somebody's taken a vehicle without the owner's consent, or even a thief. So the conduct, again, there was a very liberal view on that. It could even be the employee or the owner acting in the course and scope of employment. Conduct. What is the yardstick for negligent conduct? Colleagues, do you remember law of Delict, the reasonable person test?
Yes.
Yeah. Tell me, what is that test about? What are the two main things there?
If a reasonable person in the same position would have, the amount of degree of care and skill that person would have displayed. So for example, if you're a doctor, there's certain behaviors expected of a doctor. So would a doctor behave in that way, in that circumstance?
Yeah. So yes, so I think what you're touching on is the actual standard of reasonableness. You apply differently to experts. So if you're an engineer, it's the reasonable engineer. If you're a doctor, it's the reasonable doctor. But if you're just the average person, it's the reasonable driver, right? So in road accident fund cases, we're talking about the reasonable driver. And here we work with the test of Kruger versus Coetzee. Sorry, colleagues, I see somebody's mic is on there. Okay, do you remember foreseeability of harm and then taking reasonable steps to guard against it and failure to do so? Colleagues, somebody's mic is on. Colleagues, can I ask you to put the mics off? Can't see whose mics are on there. Okay. Yeah, sorry, colleagues. I see now that there are some questions in the chat. I'm not able to see them when I've got the slide going. So just shout out then, okay, like what you have been doing so far. Okay. Continuing, do you all remember the test for negligence, Kruger versus Coetzee? That's a locus classicus test. Colleagues, you still with me?
Yes, I think a reasonable person should foresee the danger and act quickly to prevent the danger taking place.
Yeah. So if you foresaw the harm and if you foresaw it and you didn't take reasonable steps when the reasonable person would have, and you fail to do so, then you are basically negligent. Right? Now, this can apply to the pedestrian as well. It's not necessarily the driver, because there's negligence that applies to pedestrians, people walking on the streets, basically. It doesn't apply only to the driver, right? Still following? So negligence can be proven. There's prima facie negligence, right? But with that also, you still need to provide evidence. Do any of you remember the maxim of res ipsa loquitur from Law of Delict, where they say it's the maxim that says the facts speak for themselves? So they normally rely on this maxim. For example, I think there was a case where both drivers were unconscious, one even died, and the other driver fell unconscious and couldn't even remember how the accident happened. So we don't actually have any witnesses to this, but what the courts could rely on was evidence on where the cars landed at the particular situation on the road, how they landed, which side of the road they were on, and then they would just apply that presumption. So that is when res ipsa loquitur will apply. And remember, with any civil case, it's on a balance of probabilities. So you want to prove to the adjudicator whether your version is the more plausible one as compared to the other party, right? So it's on a balance of probabilities. Tell me, you still following?
Yeah, Prof, sorry to
Yeah,
interrupt.
yeah.
Can I just go back? That case test, it was what versus Kutsia?
Oh, Kruger versus Kutsia.
Oh, Kruger. Thank you very much.
Kruger, I think you say it more like in Afrikaans. My Afrikaans is quite terrible, sorry. Yeah, and then that is the locus classicus case, basically. Whenever you come across negligence, that's the case that you would always use and state, like it's been confirmed many times. Okay, so anyway, we went with conduct, we went with negligence, then yeah, then we're dealing. Oh yes, I wanted to ask a question. So with the road accident fund, we always talk about negligence because that's like a given, it's always negligence. But what would happen in a case, say for example, where somebody intentionally wanted to drive over their wife? That's intention involved there. Would the Road Accident Fund Act apply?
No.
No, they would be held personally liable.
Okay, so actually, there are different theories in law, but basically, if you intentionally drive over someone, it's still considered negligence because I think it's Prof. Neertling who was the first one, or one of the first one, or maybe Boberg even, who said that intention can be considered as 100% negligence. So there has actually been cases, I think there was a case where an employer drove over the employee intentionally, and there they said no, the RAF Act applies, and they went across, they basically broke it down into the theory that intention is basically 100% negligence. So the Road Accident Fund did apply. So intention would also be covered, basically.
Sorry, ma'am.
Would we say it's gross negligence?
Yeah, if gross negligence is perfect, it's still negligence. But intention is still intention, right? Because there is different forms of intention. So the one that you would normally work on would be dolus eventualis. I don't know if you remember this from your law of delict as well. Dolus eventualis.
Yes.
Yeah.
Yes.
Yeah, that would be the main one. Yeah. So anyway,
Can I just ask a follow-up question, Prof?
Yeah.
So for example, in the example that you gave, where an employer intentionally ran over somebody, would that not also incur criminal charge? So for example, like interestingly, you are saying that the employee would claim. So would that also then qualify as attempted murder, culpable homicide? What would that be?
It can definitely qualify as that. Remember, I said at the beginning, there's nothing stopping you from concurrent claims. So you can have a claim in the Road Accident Fund, you can have a criminal case going and a damages claim going. There's nothing that stops concurrent claims.
I have a
But I think, Prof, just to be, if I understood the question of the colleague quite well, I think she wanted to check whether it would be homicide or murder on the part of the person who rolled over intentionally.
Yeah.
And in my view, I think it would be murder. That person should be charged with murder because remember when somebody dies and there was intention, then that's murder. But if it was negligence, then you
it's
can
homicide.
consider culpable homicide, yes.
Yes, you're right. Yeah. So that it normally falls under homicide. Yeah. But there's
Ma'am,
nothing that's.
can I ask? Sorry.
Yeah.
What if bus drivers were negligent,
and both sustain serious injuries, will both be able to claim from the RAF or
Yeah.
only one party?
No, they're both going to be able to claim from the road accident fund. So listen, I hope I understood your scenario correctly. So are we talking about an instance where there's two vehicles involved? Let me
Yes,
just give
both
you
will-
a quick one. Let's just say there's a stop sign. Both vehicles stop, but the one person says no, he had the right of way because he stopped first, and the other one says no, I had the right of way because I stopped first. So they both come to the court saying no, that person's wrong, and the other person saying the other person's wrong. So that's what we call mutually destructive versions of what happened, because and normally in those cases, it probably would go 50% negligence basically. So both drivers can be negligent, and it's usually in those kind of circumstances it's 50-50. Yeah, so because each driver can still claim from the road accident fund. And they remember the road accident fund steps into the shoes of your wrongdoer driver. So yes, they both can claim. The passengers in those cars can claim, and each of the drivers can claim. But what happens is then you apply apportionment, which we'll deal with a bit later on. And with apportionment, remember, whatever you claiming, let's just say your claim is 100,000 Rand, but now let's just pretend I'm the one driver. The court said, okay, we are saying one driver is 50% negligence, the other one is 50. So the one driver, his claim is 100,000 Rand, then he would be entitled to how much money?
50,000.
50,000.
Okay. Now I have another question for you, because we're on the story of negligence, and let's just say I'm a passenger in one of those cars, right? I did wear my seatbelt, so there's no negligence on my part, and I want to claim from the road accident fund. Then what happens to mine? Will mine be apportioned or not? What do you think?
Would
As
it be
a
100%?
passenger, I would think you're entitled to the full claim because you were not
Yes.
responsible for the accident in any way.
Perfect. Yeah. No, I'm happy you are following. That's great. So you're the passenger. There's no negligence involved on your part. Then you're entitled to your full claim. But if you didn't wear your seatbelt, then yes, they're going to apply negligence and they're going to apportion your claim, right? So that's normally what happens in practice. So great, understanding, I'm happy about that. Okay, now with carrying on with damages, remember I said to you, it's either you suffered bodily injuries yourself or you suffered a loss because of the death or injury of the breadwinner. Now, normally the plaintiff cannot claim for things like broken spectacles or false teeth, luggage in the car that was damaged. What happens there? A concurrent claim, common law, material damages claim, right? So you have your RAF claim, and then for those things that were all damaged, your luggage or whatever, you'll have to then summons for and then have a material damages claim. Following me?
Yes, Bob.
Okay, so if, for example,
ma'am.
let's
Yes.
just say you had your full set of teeth and then you had an accident, and in that now you lost 3 of your teeth and now you need to have implants or whatever the case may be, or bridges, there you can claim from the road accident fund in that instance. Remember, we have to put the person in the place they would have been had the accident not occurred, right? Especially for your bodily injury.
Sorry, ma'am, I have a question.
Yeah.
Who determines the amount that each claimant is supposed to get?
Yeah, so you in your claim, you will have, when you draft a summons, you will go through it step by step. You will state who's the plaintiff, who's the defendant. You will explain the causa. You will explain the negligence, how the negligence occurred in the particulars of claim, and then you will state your damages. And in the beginning, you might have a rough estimation because you haven't yet been to the doctors. Let's just say your injury hasn't come to a ripe stage to state, okay, for the next 5 years, you might still need this therapy or whatever. So in the beginning, you would just send the summons and you would basically put estimations or whatever the case may be. You might use medical legal reports as well. And then in your case, when it goes to the court, it depends on what the RAF does. It's possible they might concede the merits, saying, you know, or they might agree to the apportionment. They might say, okay, we agree our driver was 70% negligent. We agree to that. Then then you would only deal with the quantum. And the quantum, that's what normally drags out for some time. And in practice, what happens is if it's a complicated case, you will normally separate the merits and the quantum. So you will go to court on one day and say, right, I'm just dealing with the merits for now. Then we know whether the person had locus standi, etc., and you know what is the apportionment that gets applied. So that's the merits of the case, and then you will deal with the actual quantum. That because there's different heads of damages, but we'll see that just now. I think just now. Yeah, still following me?
I'm sorry, Prof. Could you please repeat that?
Which part?
The part about the quantum and merits. I wasn't so clear about it.
Okay, so in a claim for the road accident fund and a lot of personal injury claims, you might have to deal with the merits of the case first. So the merits of the case in the road accident fund claim for is, was the car motor vehicle? Were you actually entitled to claim from the road accident fund? Yeah, did you have the locus standi? Was the other driver negligent? That's the merits of the claim, because we're not dealing with money or calculating the money yet. That's the merits, right? So normally what happens is you will have a case, but you'll split the merits and the quantum. So when you go to court, you agree with the road accident fund. Or if you're working for the road accident fund, then you agree with the other party that, okay, we're going to just deal with the merits for now. So first we deal with the merits, and then the merits, most of the time we're dealing with negligence. Like we're sorting out locus standi and we're sorting out negligence. Who's negligent and to what amount? So that's merits. And then quantum is a separate issue where you are just focusing on the amount that you are allowed for each head of damage. So it can be for your special damages or your general damages. So it's two separate kind of questions or types of questions, if I could say. Following me?
Yes, thank you.
All right. Okay, do you all remember
No.
causation? Who said no and why? Who said no? Someone said no there? Okay. Since I can't hear anything, I'm going to carry on. Causal link. Do you remember the But-for test? Do you remember that causation is, there's two legs to it? It's the factual causation and then there's a legal causation. The factual causation is, it's factual, it's very easy to prove. But legal causation, it has to limit liability. So for example, you cannot be liable for a whole car pile up, maybe, for example, or I don't know, something that could have happened, and you could be liable for a whole sequence of events that started with you, like the person that spilled oil. Remember that one case where we said the oil was spilled there? Can you be liable now for every single vehicle that comes across, for example, even 3-4 days later? But anyway, legal causation deals with that. And if you remember from the law of delict, it's the case of Mogethi, where we use the flexible test. And can anyone tell me what the flexible test is? It's basically that the consequences must not be too remote, right? Colleagues, are you still there with me?
Yes, we are here.
Okay.
Yes.
Do you remember the two tests for causation?
Yes.
Ah, okay, good. Right, an interesting one is road accident fund versus Russell. So in this particular case, the claimant's husband, he sustained injuries in an accident. Yes. And then he underwent a lot of personality changes and suffered from severe depression. That was a big part of it. He suffered from severe depression. Do you remember that bodily injuries covers mental injuries as well, right? So your brain and nervous system are connected to your body. It's still considered as bodily injuries. So in this particular case, the husband committed suicide. And even though the suicide was intentional and deliberate, the court said it didn't amount to the break in the causal link. So there was no novus actus there. There was no break in the link. And basically the court said no, because of the accident, the sequence of events that happened caused his death in the end. And the wife she was entitled to claim loss of support. Why loss of support? She wasn't personally injured, but she suffered loss because of the death of her who?
Husband.
Yeah, who was
Of the breadwinner.
The breadwinner.
Yeah.
Breadwinner.
Thank you,
The breadwinner.
colleagues. I'm glad you're following me. Great. Okay. Next item. The accident must occur within the Republic of South Africa. And I have had questions where colleagues ask me, but what if it's that land between the border of Zimbabwe and South Africa of no man's land? So there again, we're going to have to consider what falls within the territory of the Republic of South Africa. Yeah, I haven't honestly heard of an accident on that border bridgeway there, to be honest, but that question, colleagues, they like to ask me that. So I'm just telling you the answer already, okay? As long as the accident happens within South Africa, the RAF should be liable. And there's a case of Bangiwe. Oh, this was an interesting case. Bangiwe, here it happened on an underground mine. And then the RAF came back and said, but listen, it's not any place in South Africa, right? Because it's underground. And then the court looked at it and they took a very liberal view and they said, no, it's any place. And that actually includes underground. So colleagues, we've come to the basically the end of section 17, which is most of the requirements that you need to know. Are you all still following me?
Yes, I was
Yes,
asking, would a foreigner be also able to claim from the road accident fund?
I didn't get your first part. Would who be able to claim?
Will a foreigner,
Yes.
will a
Yes.
foreigner be able to claim?
Yes.
Even
they
if-
would be.
Okay, I
It
can't
applies
get.
to everyone on the road.
A foreigner.
Oh, a foreigner.
A foreign
Yes,
national,
yes,
ma'am.
it does. Yes. Oh, yes, that is another thing. There was some time back, there was a really a well publicized case of a German foreign national that came on holiday here and got injured. I can't remember if it was Cape Town or Kruger National. Not Kruger National, sorry. That's a different story. It was in Cape Town and yeah, I think the husband died and in those days there was no limitations like what we have now. Some of the limitations, it didn't deal with passengers either. But the amount that the lady got, I think the wife got, was something like, I can't remember, it was 12 million or something, because we're looking at foreign earnings in another currency. But yeah, bottom line
But
is
why?
foreigners can.
But
yeah, it's.
But why does it? Does it matter if they are legally here? They've got all the
Yeah,
papers.
it
or
does.
that's better?
So very, very recently, right? I think we're talking about literally a few weeks or a month ago, I read in the legal brief that if somebody is illegally here, they cannot claim from the road accident fund. The court ruled, I think it was in the High Court, so it can be that it's going to go on appeal, possibly. But it was ruled in that court to say that no, if you are here illegally, you can't claim. It sort of comes down to if you are wrong, you can't claim kind of thing. If you commit murder, you can't claim, or if you obtaining money in an illegal way, you can't claim for the loss kind of thing. It's going along those lines. So that's the maxim that apply. But I did read that case. So foreigners generally are allowed, but if you illegally here, this one court has already said that no, you can't claim from the RAF. So before that, yeah. So
What's your
was the
view on
case.
that judgment?
What's my view? Sure, it's like a rock between a hard place because you don't know the reason why people are here, but then again, you understand the taxpayers' money and what they're being used for, and is it in the right way? If you are doing something illegal, should you be entitled to money? So yeah, it's a very long debate. Academics go on about it quite a bit, but I will leave it at that, colleagues. I wanted to ask, do you want to have a short break? A lot of information overload at the moment. Okay.
Yes,
please.
Okay, so it's now almost 7.
10 minutes.
We're going on until 8:30. So should we take a 15-minute break?
Yeah, it's fine.
Yes,
All right.
it's fine.
Thank
15-minute break, colleagues. I'll see you back at 15:15.
Thank you.
All right. Okay.
Yeah.
Are you guys still out there? Is someone out there?
Yes.
Yes, we are here.
Yeah.
I'm
Yes,
looking
we're
for
still here.
that recording of the exam discussion. They say they're going to put it on the site. So I'm not sure. I haven't found it on the site, on the profile. Does anybody in possession of it, maybe?
I don't think it
They
was
said
uploaded.
The exam discussion that they had yesterday from 12 o'clock until 1 o'clock.
I don't think it has been uploaded yet. Maybe we
they
should
said
ask Lisa.
Monday.
I'm also struggling to get it.
Okay, I thought you guys might have it, so you're sitting in the same
No,
boat.
we don't have the recording as yet.
Okay, thanks.
It might as well be. Kill anyone who uses this one.
Yeah, no. Don't try to lack of enough. Oh.
Old are you now?
Tebogo, please mute yourself.
Please, man, switch off your mic. We are hearing your birthday stories. Please.
Unawani?
Guys,
Tebogo, please mute yourself. Tebogo.
I don't think Tebogo is closer to his laptop. He's singing.
Yeah, kumatata.
Okay, colleagues, it's 1:15. I want to continue. We've still got a lot to get through. Are you all back with me?
Yes.
Yes, ma'am.
Thank you. Yes.
Yes. Okay, good. Okay,
Yes,
so anyway, as a recap, we dealt with section 17, that dealt with all the basic requirements. And I want to deal now with section 19, especially remember section 19 I told you is absolute total exclusions. So one very important one is section 19 subsection A. So here, this section says the wrongdoer will not be liable at common law, and then it lists the circumstance. And that applies where section 35 of COID Act applies. It's a statutory exclusion as well from COID Act. And here, the scenario that we're looking at is where the employer is the driver and the employee is the passenger or pedestrian. So in that scenario where you as the employee, the worker, is injured by your boss, the employer, then they said that, and COID Act is applicable, then they say that the wrongdoer is not liable at common law. So therefore, the RAF is not liable at common law. Therefore, you cannot claim from the Road Accident Fund. So there your claim lies with the COID Act, and that's the Compensation Commissioner. And one of the main cases there is RAF versus Moniani. And I think they deal with it there in your paragraph 14.1 of your study guide. I think there's a whole section on the COID Act, if I'm not mistaken. So, following me still?
Yes, ma'am.
Yes,
Okay.
yes, ma'am.
Right, now section 19B subsection 1, that one totally redundant. You shouldn't even bother with it. That said, a paying motorcycle passenger for reward is excluded. It was in conflict with another section. So anyway, a very long time ago, it was rendered obsolete. So don't even worry about that anymore. Why doesn't it want to go down? There we go. Is that my next page down? Right. Then, okay, just to give a bit more explanation on this employee that was injured by the driver, and the COID Act is applicable. There's another case there. I think it's Juiced versus Score Supermarket, CC decision. And there it just confirms that you cannot sue the employer because your rights then lie with the Compensation Commission. And there also you cannot claim from the RAF. So there you only recover compensation from the Compensation Commissioner. One important thing there, paragraph 14.2, it actually states who is an employer, more or less. Because you come across certain situations where you're not sure if somebody is actually the employer, but if there's a certain measure of control over you, then they are considered the employer. So have a look at that in your own time. But this is a really important exclusion to remember in practice, colleagues. All following me still?
Yes,
Yes,
ma'am.
ma'am.
All right.
Yes, ma'am.
Sorry,
Okay.
can I interrupt here?
Yeah.
So if an employee is injured on duty, say
Yeah.
they're delivery driver and he's delivering goods, he's injured, is that a COIDA case or RAF?
So if the COID
I
Act is
think it's a
applicable,
code, yeah.
yeah, if the COID Act would be applicable there. So the claim lies against the Compensation Commissioner because it's another, remember, like the RAF, is another statute that's regulating things where you're in the course and scope of employment, basically. So it's just this one instance now where we have the COID Act as well as the RAF and the common law all in the mix. And here the one statute is saying that here in this case you claim against the COID Act. But it's only in the instance where you are injured by your employer and whoever qualifies as the employer, basically. The employee can even be a pedestrian, right? Remember I told you about the one that was deliberately injured, yeah?
Just for clarity, in an earlier example, you gave an example of a case where an employee was driven over intentionally by an employer, and
Yeah.
you said they could claim from REF. So does that not, or was just that an example, or because
Yeah,
that's now
yeah.
contradictory to this?
Yeah, so that was just an example. If the COID Act applied, basically in that scenario, yes, you are right. I just gave it as an example of where intention can apply. But here in this particular instance, the employee was driven over by the employer. So let's just say in that example that I gave about intention, it was two employees. Let's just say there was a co-employee and he intentionally ran over the other guy. Now, in that case, the COID Act is not applicable. So it's only applicable where it's employer-employee, right? And the employee is the one who actually is the driver. This is the only scenario it applies where it's a complete exclusion from RAF, yeah?
Yes. Prof, what about in a situation where that employee died and then the third party needs to make a claim? To whom a claim is going to be made now?
Compensation Commissioner, and yeah, it's probably Section 35 is going to apply. So you remember, it won't be against the RAF. RAF is not even involved there now. It's excluded. Section 19 excludes it.
Okay.
Yeah.
Ma'am, is the employer himself can claim against RAF or?
Yeah, But yes, they remember if the employer is the one that got injured, let's just say the role is reversed. We've got the employee who's driving and the employer is injured. Then COID Act is not applicable. You can claim from RAF. Do you understand?
Okay, thank you. Yes, ma'am, thanks.
Sorry, ma'am. Is the Kuwait compensation commissioner?
Commissioner, yeah. So it's basically your compensation. Yeah, it's the what's it? Compensation for Occupational Injuries and Diseases Act. Yeah, that's it.
Sorry, just interrupt there. But the employer is also deemed to be an employee of a company if it's a company.
No,
How does
so
that work
there,
out?
so there, I'm telling you to look at paragraph 14.2, right, in your guide. There, they will kind of explain in more or less who's considered an employer. So it's normally someone that has a certain measure of control. You are still an organ of the company, but you consider the employer because of your measure of control that you have over the employee. Do you understand?
So,
Thank
Prof,
you. Yes.
so, sorry, Prof. So in that particular instance, the that particular employee, stroke employer, makes the company vicariously responsible then.
Wait, now I'm getting a bit confused. Makes the company no. We're talking about an exclusion where the RAF is not going to pay out anything, or they're not ever going to be liable, and it's only in the instance where the employer, and there the lady pointed out what qualifies as an employer. I told her to have a look at that paragraph, because an employer is somebody who has a certain measure of control over me. So it's probably management or something. And then the employee. It's only in that situation.
So let's assume that the manager or the supervisor in that particular case is the wrongdoer.
Yeah.
Obviously in this particular instance, he or she will then qualify as an employer.
Yeah. Basically, they would be the employer, and in that instance, Section 19 kicks in with Section 21 and Section 25 of the COID Act, and there the RAF is not liable. So in the scenario where it's two co-employees together and either one gets injured, then it's not excluded. You can claim from the road accident fund still. Do you understand? It's just one of those specific instances that you need to know about. Following still?
Yeah, no, fine, thank you.
Sorry, ma'am. Please repeat that. The last part.
Yeah,
So the last part, was it about the co-employees?
Yes, because I was doing my articles recently, and a guy who was a security guard got injured whilst in a taxi traveling with another employee who was a driver. Like it was the company car. It was like a Quantum taxi, Toyota Quantum. So he came to us to claim for RAF, but then we had to wait and find out with the company whether they had claimed from COIDA on his behalf. And then, well, from what I know, we have to wait for them to first pay, and then we could continue with the claim. So I'm not sure. Yeah.
Yeah, so it's basically that section applies where that person is considered the employer, and if the employer was the driver, it's possible that the exclusion applies. I'm not sure why you still have to wait. It's the exclusion is supposed to apply, but we don't know I don't know the full circumstances. It can be that the COID Act is still applying, and RAF. Has the RAF responded to any correspondence or anything to do with the claim yet?
Not so far. We're just collecting the information.
Yeah.
Yeah.
So I think
So,
you'll have to hang on and wait to see what they
sorry
say.
to interject. Okay. So you said when it's co-employees, then the exclusion does not apply.
No, it doesn't apply. The exclusion
Okay.
won't apply. Yeah.
Okay. Thank you.
And then just in a general sense, right? Let's just say you are getting money from, let's just talk about the two co-employees. They were injured in an accident. and exclusion doesn't apply, which means they can claim from the RAF. So there, what happens in the RAF says that we want to know what have you claimed from the COID Act, and I think on the form there it actually has a specific section where you've got to fill it in. So because remember I said to you that the COID Act and the RAF, they're government entities, they're not going to pay double. So if the COID Act plays, the RAF's not going to pay. So what they do is the normal golden rule they apply is that first you apportion. So if the Apportionment of Damages Act applies, so if any apportionment applies in the terms of negligence, remember I told we had that scenario about the claim, 100,000 Rand, 50,000 Rand, 50% negligence, you get 50,000 Rand. So what the rule is, you first apportion and then you deduct. So that's just something to keep at the back of your mind, right? Just keep that at the back of your mind. Okay, remaining exclusions. Now, what I want to talk about, 19C to F. Yeah, somebody was speaking there.
Yes, it's me, ma'am. Sorry. I had a similar, I'm not sure whether it will be of assistance here. I had a similar incident where I'm working, where we claim for quota and also, what do you call, RAF.
Yes.
And the RAF wanted, what do you call, the fund, whether the quota is paid.
Yes.
The as paid so that they can deduct the money from there.
Yes, that's
So
exactly what happens.
both.
So yes, that's right. So they will wait to see what COIDA has paid. They want to see, they want to know what the amount is. And then if any apportionment applies, that's the rule. They first apply the apportionment and then they deduct. So they don't do it the other way around where they apply apportionment later. So it's just something to remember at the back of your mind. Whatever COIDA pays, then if there's an apportionment that applies, then you apply the apportionment first and then you deduct the remainder basically. Yeah, but you're totally right. The next exclusions, right? Subsection C to F. These ones are not absolute exclusions. So the previous one I would say is a relative exclusion. Sorry, it was an absolute exclusion, and C to F are relative ones in the sense that even though this is going on, let's just say there's unauthorized handling of claims. Let's just say it's not the third party himself who instituted the claim or an attorney, but it was an tout or an assessor. So there you are, it can be excluded, but if you rectify the situation, like you do the claim yourself or you get an attorney involved or a legal practitioner, then it's no longer an exclusion. So these are just basically relative. They are not absolute, meaning you can fix the situation. So anyway, 19C deals with unauthorized handling of claims. 19D deals with agreements with unauthorized persons. That's basically people that are not attorneys or legal practitioners. 19E is where you say, I don't want to go for a medical examination or I don't want to supply the further information that you want. F is where you don't supply the compulsory affidavit and any other statements. So all of these can still be fixed if you just supply the documents or you go for the medical exam or whatever the case may be. Following me?
Yes, ma'am.
Okay, good. Right, 19G. Now this is an absolute exclusion. This one totally excluded. So anything that happened, basically claims from the 1st of August 2008 onwards, if you were involved in a motor vehicle accident and you were a secondary victim, and here the emphasis is on secondary. If you were a secondary victim of emotional shock, then you cannot claim from the RAF, right? You have to claim from the wrongdoer driver in terms of common law. Are you following me? This is really important.
No, Prof, can you repeat?
Following.
Okay, let me repeat it just for the sake of some of you that might still get lost. So remember, in an accident, you can either be a primary victim of emotional shock. Remember, I said emotional shock. Sometimes they call it nervous shock. It can be post-traumatic stress syndrome. There's a various number of things that can qualify under that. But basically, I would say it's like mental harm in some sort of way. So it's not actually manifesting as a physical injury like a cut or something, but it's a mental harm. You're now suffering emotional shock or whatever the case is. So you have a primary victim. The primary victim is the one that was personally involved. So let's just say it's me. I was involved in the accident. I am a primary victim. A secondary victim would be someone like, let's just say, I was knocked out unconscious and they called my mom and they told my mom to say, you know what, your daughter was involved in an accident. She's critical. She's in ICU. Now my mom suffers emotional shock from hearing this, right? And she's now not herself. She can't function anymore, whatever the case may be. But she would be considered a secondary victim. A secondary victim is somebody either hears about the accident afterwards, and if they're hearing it about the primary victim, or they see it. So there was a case where Dion Bester, where he witnessed his brother being knocked down by a vehicle, whatever, being involved in an accident. So those are the secondary victims. So now 19G says, if you are suffering secondary emotional shock or nervous shock or mental harm, then you don't claim for that emotional harm from the RAF, but you claim it from the wrongdoer driver in terms of common law. And that only applies after accidents after 1st of August 2008. Is that clear now?
Yes,
Yes,
ma'am.
yes, ma'am.
All right, great.
Prof, we don't have 19G in our study guide.
You don't have?
19G.
Page 64.
Okay,
Yes.
somebody
Check page
found it.
64.
Paragraph 5.4.2. Sorry, colleagues, I prefer to use paragraph numbers because yearly the guides change and the page numbers change. It's just easier to work with paragraphs. Okay, additional requirements. Now, section 17B, and this is read with regulation 2. It's paragraph 7 of your guide. This is with hit and run claims. Remember, I told you in the beginning, you get identified and unidentified claims. So with the unidentified claims, which is also the hit and run claims, besides having those requirements that we spoke about earlier, like conduct, driving, causation, damage, all that, now there are other requirements that you must comply with. Colleague, someone's mic is on. Okay, so in hit and run claims, there's other requirements. So first of all, it says comply with the Road Accident Fund Act. Then there must be unlawful and negligent driving by an unidentified motor vehicle. Now here, unidentified has a very specific meaning. It doesn't, for example, let's just say you know the make of the car, the model, but here in this instance, you don't know who the driver is. Then it's considered unidentified. So in other words, you must know who the driver of the vehicle was. Because remember, vehicles, they change ownership all the time. So at the time of the accident, you need to know who the driver was. That's the important thing. So that's the difference between an unidentified and identified claim. You need to know who the driver was. Following me?
Yes.
All right.
Yes.
And then yes, and then obviously it's obvious
Yes,
that the
ma'am.
bodily, yeah, thank you. And then the bodily injury or death, depending on whether you're claiming loss of support, it must be caused by this unidentified motor vehicle. So it's not necessarily the vehicle, but it's the wrongdoer driver. And then to bring back things that are no longer applicable, I just want to mention it.
I have a
Don't,
question.
yeah.
Does this mean that if you do not know the driver's name or anything, and then you cannot claim from RAF?
No, you claim from Road Accident Fund, but it's now considered a what claim? Which of the two?
Unidentified.
Unidentified. Hit and
There
run.
we go. Yeah, that's it. So it's an unidentified claim. But it's important to know whether it's identified or unidentified, because different prescription rules apply. And we're going to come to that just now. So just remember that you need to know that difference, right? These, in terms of the regulations,
Sorry,
there was, regulation 2. Yeah.
Hello. Yeah,
Yeah.
just a question. Could you please go back to your previous slide?
Yeah.
Yes. Who bears the honors to prove that the I mean, yes, yeah, to prove that the driver was unlawful and negligent in his or in a conduct.
A claimant. Remember, the person who's claiming has got to prove everything.
So if that person happens to be deceased.
Okay, so are you talking about a scenario where the dependents are claiming?
Yes.
So there, the claim is you will be what type of a claimant? You the second claimant. You're not the one that was personally injured, but you claiming because of loss suffered due to the death of your baby. Yeah,
That's correct.
Yeah, you are entitled to claim, but then you become the claimant. You have to have the locus standi to claim, and that we're going to come across just now as well.
Okay, thank you.
All right. So the next slide is additional requirements that have actually been struck off, redundant, no longer applicable. It's just for noting, really. Previously, they said you had to take reasonable steps to identify the owner.
Ask you a question before you take this next slide.
Yes. Yes.
I don't know how relevant am I going to be on the question that I want to ask. I just want to check in relation to a claimant in a child who deceased. Why would RAF not compensate, you know, for the loss of a child to the parents who might have lost a doctor or an engineer? My understanding is that they only pay for funeral expenses. So, but they don't pay claim itself.
Yeah. Okay, so we are going to go later on through that. We're going to deal with locus standi, like the other question that was asked just now, and we're also going to deal with the types of damages. So obviously, if you didn't get any loss, remember your damages must be, you must have some kind of a damage. So what is your damage where a child dies? Your damage is you're not losing money because that child didn't earn money for you, for example. It was too small. But maybe you suffered like emotional shock or PTSD or something. Then you can claim maybe general damages. So, and also there could be that, you know, let's say, for example, the child went into hospital and was in hospital for about 2 weeks, and you still had all those expenses incurring, and then you can claim for that. So it just depends. You've got to look at the situation and decide what is the damage, and then you can claim for the heads of damages that are applicable. Does that answer your question?
Yes, it does answer my question.
Okay, great. Okay, coming back to the slide.
I'm sorry, Prof. What happens in a case where the mother is deceased in a hit and run and there's children left behind?
Loss of support claims.
Okay. Oh, and what if the mother was not working? She was unemployed.
Yeah, that's what I'm saying is you've got to figure out what was the loss or the damage that was suffered. Again, basic law of damages principles. You can only claim damage or loss that was suffered that resulted from a motor vehicle accident, right? So you've got to come down to if there's no loss, if they didn't have financial loss, then you can't claim the special damages, but they might have had general damages, loss in the sense of emotional harm, shock, that kind of thing.
And so it means that the children can bring in a claim claiming emotional loss.
Yeah, in other words, those ones that fall under general damages, kind of. But we're going to come to that just now. Not
Prof,
just
sorry, then you would be claiming with bringing a civil claim. Am I right? You're not going to be able to claim from the RAF.
If the mother died from a road accident, a motor vehicle accident, there are definitely heads of damages that you can claim from, that you claim from the road accident fund. So yeah, it's still possible, but we'll come across the heads of damages just now, I hope, if we move on. Okay, colleagues, I'm really happy that you are asking questions that surely I think will be answered soon. If not, you can ask me again, right? But anyway, coming back to hit and run claims, the ones for noting that are no longer applicable, reasonable steps to identify the owner. They had this rule that you had to report it within 14 days. That was terrible because there were a lot of claims that that couldn't comply with that. It was found unconstitutional. Then they also scrapped the one of physical contact. They said it doesn't necessarily mean that you have to have physical contact with the vehicle or whatever. And then the certificate, but that's actually still required. So hit and run claims, and now here I'm dealing with the current legislation, and that's under your paragraph 7 in your guide. And there it says basically all claims arriving out of motor vehicle accidents, and there again we're using the date, 1st of August 2008. We need to comply with regulation 2.1. And then they state that you must still comply with section 17(1)(a) and B, but big difference here is the claim must be lodged within 2 years from the date of cause of action. So cause of action has 2 dates. We're going to come across that just now. Just remember, hit and run claims, the period is 2 years from date of cause of action. Then once the claim is lodged, the general thing is that once it's lodged, the period of prescription then extends for 3 years to equal 5. Okay, don't panic yet. I'm going to show you the next slide.
Does that you mentioned refer to medical certificate?
The medical certificate, we're going to come across that soon. RAF4, I think you're talking about. Okay, but basically, I just want you to know at this stage that important thing is it's 2 years within which to lodge, and then it gets extended to a total of 5 years. But I'm going to show you a diagram just now, which will make it more clear. With hit and run claims, it's always a factual question. So it depends on whether you've identified that driver or not. I think we mentioned here there's a case of Pithy versus Road Accident Fund, practice manual paragraph 7.4. Basically, if it turns out that you find out who the driver is at some stage, then it does become an identified claim. Then your period of prescription extends. So for claims that are identified, in other words, not hit and run, your initial period within which to lodge a claim is 3 years. But for hit and run, it's 2 years. So there's that difference of a year. And that's why the fund is really sticky on this. Prescription is really important to note. And I've just made a note here that make sure that if you do these hit and run claims, look at the checklist on paragraph 7.7.
Sorry, ma'am, can I ask something?
Yeah.
What if the person is in hospital and is not able to claim within 2 years? What happens then?
So the prescription period is it cannot be extended or condoned, but there's an exception that applies to people that are non-compos mentis. In other words, people that are in a vegetative state. That too, my dear, I'm going to come across that soon. That question is going to be answered as well. If not, you can shout out again, all right?
Okay.
All right. So just to show you this diagram, so it's in a way that you can actually see it. On the top, it's identified claims initially, 3 years to lodge. The moment
Sorry, Prof, before you continue.
Yeah.
Sorry, Prof.
Yeah.
Just a quick question in terms of prescription, right? So what happens to a case which actually prescribes,
Yes.
I don't know how to say the word, while it's in the
prescribed.
hands of the RAF. So you've lodged, but they've not come back to you when the prescription time comes. So
okay.
will that
So the
continue, or
moment you
prescription
lodge,
doesn't count while it's in the hands of the RAF?
Yeah, no. So the moment that you are lodged, basically it's held in abeyance. Now it's not prescribing. It's held in abeyance, but before the end of your 5-year period, you must issue summons. So initially you lodge the claim, you want to wait for them to give some kind of response. If they don't give a response and your 5 years is coming to an end, you have to issue the summons. And the moment you issue summons, now you're starting a whole litigation process. And that put prescription at bay. It doesn't prescribe because it's in abeyance now, basically. It's like at a stage of its, what is the right word? It's cut, basically. It's not prescribing. It stops at that stage. Do you understand? Yeah?
Yes, I do. Thank you.
Okay.
So,
So can you see the difference here between the
hello, ma'am.
identified and unidentified? There's either 2 years or 3 years, but in the end, it still totals to 5. Yes, you had a question, sir?
Yeah, I just wanted to find out the prescription will be interrupted by lodging of the summons or maybe by, yeah. I just wanted to find out that.
Yeah. So you
Then
have
it will
to
be a
lodge.
pending case.
Yes. So in
But
other
what
words,
about the 60 days?
yeah, we're coming to that just now. So let's not jump the gun for the moment. This is just basic principles, right? Okay. These are basic principles. Yeah.
Sorry, just a question on your previous slide. If a claim is unidentified and you've lodged it within 2 years, and in month 6 you become aware that you now can identify the driver, it becomes an identified claim. Does the 3 years then start from date of identification?
No, no, no. So then
you continue?
you still work on date of cause and action, but it's now that your initial period is 3 years, but you've already lodged anyway.
Okay.
So yeah. Okay. So those are just the basic principles, right, colleagues? We're going to deal with more nitty-gritties just now.
Fund drafts legal pleadings and contracts for clients, drafts correspondence.
Sorry. Is your mic on by mistake? Sorry. Or are you asking a question? Okay. Now we want to deal with issuing and serving summons, which there's the word suspends prescription. I don't know why I'd lost it there for a minute. Okay, so you have cause of action. Remember I spoke about earlier cause of action. There's 2 different periods. So it's either the date of the accident, and the date of the accident is applicable where you are claiming special damages like hospital costs, medical costs, loss of earnings, or general damages. Then the date of death, that's the second cause of action that might apply. That is when you are claiming loss of support or loss of maintenance. So remember those 2 different starting periods of prescriptions, if I can say it. That's date of cause of action, 2 different time periods which you must remember. Are you following me? Colleagues, now
Yes, we are.
Okay. Right.
Yes, ma'am.
Now we're dealing with specific things, minors. Now here on this slide, I'm just want to talk about identified, not unidentified. We're talking about identified claims here and minors, right? So the general rule is that for minors, they have actually got 3 years to lodge. So in other words, you must lodge the claim, but 3 years after the date of attaining majority, right? So that is 3 years after they turn 18. Minus, I don't know why is this in saying unidentified claim 2 years from date of cause of action. Okay, there's specific things that apply with hit and run claims. But anyway, with minors, normally it's 3 years extended to 2, but unidentified claims, prescription starts to run actually from the date of the accident. So I think there's a bit of confusion on the slide, which I must fix. Okay, method of calculation. It's the first day included and the last day excluded. I think I've written here C. Gabuza versus RAF. I hope I pronounced that right. Oh yes, this case was important because the 5-year period actually ended on a day which was not a court day. The court was actually closed, and because it was closed, they couldn't issue and serve a summons on that day. So the court then said, okay, it's the 5-year period then ends on the next court day or the next day that the court was open or working day. So that was an interesting case there that clarified that for colleagues. And then just a simple exercise. It is actually in your notes. I'm hoping you haven't checked it yet. But let's just do an example. If there was the date of accident happened on the 2nd of September 1998, and we are dealing with an identified claim. Remember, identified. What is the date of prescription to lodge the claim? So identified is
September 2001.
Yeah, but what date of September?
The 3 years would lapse in September 2000. The 30th of September.
Yes, 1st of September. Okay, great. And then to serve the summons?
2 years.
2003,
2003.
September 1st.
Yeah, so it's gonna end up to 5 years, right? 1st of September. And then and what about a minor in an identified claim?
Would it be when they turn 18?
Yeah, so your prescription starts to run on the day that they turn 18. Yeah, so that's the date you start calculating. Okay, great. I'm glad that you are following on that. Minors. Now there's a bit of a sticky situation, which is actually probably not applicable right now, but I have to tell it to you. So if a cause of action arose before the 1st of July 2007, prescription will be suspended and will only start to run when the minor turns 21. Do you remember there was at some stage age of majority was actually 21, not 18, and then they changed it. So that was the reason that was there. I doubt you're going to come across this in practice. It's really just for noting. But anyway, from 1st of July 2007, minor is no longer minor once they turn 18 years old, and prescription starts to run when they turn 18. So in identified claim, 3 years to lodge from the date of turning 18, and it ends up to a total of 5 years from the date of attaining majority. So you must lodge and you must issue the summons before the 5 years after turning 18. Are you still following me on prescription?
Yes, we are.
Yes, ma'am.
Great.
Yes, ma'am.
Yes.
Okay, thank you so much, colleagues. Now some practical aspects, right? So normally a claim of a minor, they cannot represent themselves. So normally the guardian or the parent, which is the mother or father, they would be the one that's bringing the claim on behalf of the child. So it's the parent acting in the representative capacity. But now I want to throw something in the spanner. Let's just say the child is, let's just say the child is 10 years old anyway, and the child was injured. The child went to hospital, and the child also suffered some post-traumatic stress disorder. And because of that, the child can't go to school for 6 months. Because of that, now the whole year's been delayed. He has to repeat the year. So in those instances, what will the parent be claiming in the representative capacity and personal capacity? Let's just make it easier and say the father is the breadwinner. So we don't even involve the mother in this. The father is the breadwinner. So the father in his personal capacity will claim for which damages, do you think?
Emotional shock.
For shock.
For medical damages.
Yeah.
It will be a pain and
Now
suffering.
I'm going to
Would it be
correct
for
you.
school fees?
It will be general
No.
damages.
General damages.
Pain and suffering, yeah.
Okay, so let me explain to you. So in the representative capacity, the parent will claim the hospital cost, the medical cost, that kind of thing. Sometimes we're dealing with a situation. I think one of the exam questions in some past paper I remember seeing was a uni student, and the university student was supposed to become a medical doctor. Because of the injuries, couldn't. They had to settle for a much lower job, if you could say, and then there was future loss of earnings as well. So the parent will claim in a personal capacity, the parent will claim for the hospital expenses. Why? Because it's coming out of the parent's pocket. So the hospital and medical expenses is from the parent's pocket, so that is in the personal capacity. But a representative capacity is for the general damages, which is your emotional shock, etc., and future loss of earnings. Do you understand that difference?
Yes, we do.
Okay, so even in the summons and particulars of claim, you could have the parents saying Mr. X is acting in the representative capacity as well as in his personal capacity. And then in that particulars of claim, when you come to the paragraph on damages, then you separate it and you say damages in personal capacity and you'll list them, and then damages in representative capacity and you list them. So that's one way of dealing with it in the particulars of claim. Then I had a question. What if a bread, yeah?
Sorry, I want to ask a question. For how long in the future can you make a claim for? So if it's a loss of income that person will, like the doctor scenario, for how long can you claim?
So the general rule is like 65, but if you remember from the law of damages, there is contingencies and things that they apply. And they look at tables and they say your life expectancy was this. But the general rule is that the age of retirement, 65. But remember, they will probably bring that down, taking into account contingencies. And they will look at a whole bunch of actuarial tables. And there you will actually get a report from the actuary that will actually calculate all that. So you just have to know that you've got to appoint the actuary, but the actuary will actually do that job. But normal rule, age of retirement. Does that answer
Is there a
your question?
maximum amount that one can claim?
Prof, if I can just ask a question. What happens in situations, for example, let's say I'm a student, I've not started working. For example, now I'm in law school. My plan obviously is to become an attorney, but now I get involved in this accident. When I'm claiming for loss of income, for loss of future income, what quantum do they use? Like, or what basis do they use to determine that loss?
Yeah, so you'll have to get an industrial psychologist involved there as well, because that person, that specialist deals with your future loss of earnings according to your profession. And then they will still apply the contingencies and they will still apply deductions. But yeah, you will try to claim. Remember, the thing is to put you in the position that you would have been in had the accident not occurred. So if the accident didn't occur, you would have become this attorney in 10 years' time. You would have been, you were quite brilliant and bright. You were probably going to become a partner, a senior partner in 10, 15 years. That's what they can try and use according to statistics and tables. But then contingencies, etc., and deductions will apply. But yeah, so basically they take that into account.
So, Prof, to understand
There's no limit. Somebody asked me about a limit that applies. There is limits that apply, and we are going to get to that soon. So before the amendments, there was no limit at all with future loss of earnings and loss of support. There was no limit, but now there's a limit.
Sorry, I had asked that question. I just wanted to find out. So you're saying that there is a maximum amount that a claimant can receive?
For certain heads of damages. Now there we're talking about loss of earnings and loss of support. Yeah, just for those heads. Yeah. Okay.
So, Prof, I'd like to find out
and
quickly.
there's something that also applies with general damages, which we're going to get to soon. Yeah. Question?
Yes, Prof.
Does
I
it
just
really
want to find
matter?
out. So, can a mother who has a kid that has recently graduated and was about to start working and was in a car accident and die, can they also claim for the future loss claim?
No, because there you're not actually suffering the loss. In the situation where the child didn't die, but it was injured to the point that, they can't function as what they should have done. Let's just talk about somebody who's a guitar player. That was his profession, or going to be. He was going to get some big contract soon with some company overseas, but now he injured his fingers and he can't use them, so he has to settle for a lesser job. Now that person, because they're still alive, they can claim the future loss of earnings, but as a parent you can't claim. But there can be an instance where, let's just say you get a child that was earning and they used to give you money per month. They gave the parents money, or they gave the grandparents money. Now the grandparents have lost the money, the parents have lost money, actual money, there they can claim.
And then what proof should they produce for that?
Yeah, I'm going to show you in the slides further down.
Okay.
Ma'am, in terms of parent in personal capacity, does it really matter if the treatment was taken in a public hospital, meaning that there was no really medical expenses? How do they how do they touch on that?
Yeah, so that too, I'm going to deal with that in another slide. But basically, if you can get treatment in a public or private hospital at this stage, you can still go to either or. And even in a public hospital, I think there is an amount that's claimed, very minimal, but there is an amount. So whether you go to a public or private, you can still claim from the road accident fund. Recently, the road accident fund, they went rogue and they said, okay, we're not paying the medical aids anymore. I think it was this week or last week. It could have been very recent. Discovery's now taken them to court, but basically the RF has to pay the medical aid still. So yeah, they still have to pay. The medical aid can actually claim as a supplier. They are not considered a third party, but they are considered a supplier, the hospital also, and they can also claim. So there are instances like that, but we're going to get to that just now. Quick question. If a breadwinner dies on impact, in other words, at the scene of the accident, can anybody claim general damages for the deceased person?
I would assume only special damages, as in loss of support, because the person is dead. So are you claiming pain and suffering?
Yeah, perfect. Okay, great. Thank you, colleagues. I just put an NB there. Remember?
In terms of in personal capacity, can you claim for funeral cost as well?
Yeah, if you were, in other words, if you were the one who paid the funeral bill for your child or parent or whatever the case may be, that was injured in the accident or died in the accident, obviously they died if there was a funeral and you pay the cost, yeah, you're going to claim it back.
Okay. And in terms
Would
of
that fall under
representative
third-party
capacity, what does general damages include? It's emotional?
I'm going to show you in another slide. You're going to see it just now. Okay. So coming back to suspension of prescription, right? Where a person, so there are instances where you can lack the locus standi, right? There are certain designated people that are considered, and here we look at certain categories. So remember, a minor doesn't have the full capacity. They have limited capacity. A mentally ill person also lacks locus standi, as well as persons under curatorship. So those are the simple guidelines there of people that kind of lack full capacity. Prescription, yes, there's the case of Malloy. It says prescription does not run against a permanently unconscious person or person in a vegetative state. That makes sense. Somebody asked that question earlier on. But in a hit and run claim, now this was important, in hit and run, prescription is not suspended even if you are a minor, you are mentally ill either. So if you're a minor, you obviously will have a person that will be representing you. If you don't even have a parent, then you have to appoint somebody. And even if it's a mentally ill person, you will appoint a curator ad litem, and they will then continue the claim for you. So prescription does not apply to minors and mentally ill, but if it's a person in a permanent unconscious state or vegetative state that they call it, then prescription does not run against that person. And that's specifically from the case of Malloy. Okay, somebody talked about 60 days. So it wasn't 60 days there, but we're talking about 120 days. This is now to issue summons. At the stage where you want to issue summons, let's just say, for example, the accident happened 1st of December 2010. You've lodged your claim already. Right? Sorry, colleagues, somebody's mic is on. Okay, so we're talking about issuing summons. Mic is still on, colleagues. Thank you. Right, we're talking about issuing of summons. So the Road Accident Fund has a specific provision, and it says there, section 26, 24, 6A and B, you have to wait 120 days before you can lodge, before you can actually issue the summons. Hang on, what does it say here? This means 120 days must left after this. So basically, technically, you can lodge the claim, and after the 120-day period, you can issue the summons. So you don't need to wait. What happens in practice, the RAF will not even respond to you till your claim is going to probably prescribe, like your end of your 3 or 2 years coming up, and you are going to be forced into issuing summons. It happens so many times. But there are instances where you can actually just straight after 120 days, you can issue the summons, issue it and serve it. Now, how you calculate these 120 days? You include the first day, you exclude the last day, and you disregard all Sundays and public holidays. And there you've got to actually physically take a calendar, literally, and you have to count the days. So if you issue the summons before the 120-day periods, it means you've issued it prematurely, and that means that prescription has not been interrupted, which means prescription is carrying on running. So be safe and make sure it's after the 120 days. It is possible that the RAF can repudiate. Let's just say you lodge the claim, and before the 120-day period, the RAF already responds, which is very unlikely, but they can respond and say, oh, we're already repudiating this claim. And if you think you still have a claim, then you don't have to wait the 120-day period anymore. You may issue and serve that summons. Are you still following me?
Yes. Please repeat the last part, please.
So the last part was, if the RAF, let's just say you lodged a claim with the RAF and it hasn't yet passed 120 days. Remember, you have to wait 120 days before you issue summons. Okay, you following me, sir?
Yes, ma'am.
Right. Now let's just say before 120 days, let's just say day 60, the RAF writes back and says we repudiate this claim. In that instance, because you've got it on paper, they've repudiated it, and you still think you have a claim and you want to continue, you can issue the summons. So you don't need to wait. That's the only instance where you don't wait for the 120 days.
Got you, ma'am. Thank you.
Okay. All right. Now, in terms of the amendments, section 17.2 says that costs, right, cannot be recovered unless you issue summons. So if you know those attorney and client fees, if you are involved with a client and you are at the stage where you have reached settlement before you issued summons, you cannot claim those costs from the road accident funds, your party and party costs, for example. So that's what section 17.2 amendment states. So previously you could, and now they said any accident after the 1st of August 2008, if you haven't issued summons and you already settled, you can't claim costs from the RAF. And that's paragraph 5.7. Following?
Yes, ma'am.
Okay, great. We're on 8 o'clock. Right, I'm going to keep going. We have got third parties who have locus standi. Remember we said somebody asked questions earlier on who's a third party, whether they qualify. So this is now paragraph 8 of your guide. So the general rule is that every natural person with full legal capacity has the capacity to litigate, right? Now those persons, those that don't have full capacity, children, minors, etc. Those that do have full capacity and they are unaccountable or unaccountable. What am I writing here? People with full capacity need the assistance of someone. Okay, so basically we're coming to people that don't have full legal capacity. They need somebody to assist them on their behalf. Next slide. Let's continue with this. Who qualifies as a third party? So remember we said you have a person that's personally injured. There it can actually be an unborn person. We call it an unborn person, basically a fetus, right? Does anyone remember law of delict and family law, that NASA jurisdiction? Anyone remember?
Yes, we do.
Yes.
Yeah.
Yes.
So basically,
Yes, ma'am, we remember something.
yeah. So an example, a mother in a car accident, a mother's in an accident and the fetus is injured and she loses the fetus because of this accident. The child is still considered third party. A minor, the guardian of a minor in his own right. Remember, that's the parent who wants to claim the hospital expenses. A married person, whether in community, out of community or property. It even covers an unrehabilitated insolvent. There was an actual case for that. Then we have third parties who suffer loss of support, and they have written paragraph 8.3.3 to 8.313. There's a whole list of them there. So it covers claimants that are legally married. It can be a civil marriage. It can be a customary marriage. It can be a same-sex union. Live-in partners. Partners also qualify. There's duty to maintain contractually created. An example is a husband and wife got divorced, and in the divorce settlement, the husband had to pay the wife, let's just say 1,000 rand a month. And now what's happened is the husband has died, and now the wife, ex-wife, she's lost that 1,000 rand a month. Because that duty was maintained contractually in terms of that divorce settlement, that ex-wife qualifies as third party. You get parties that are solemnized by other rights. And there we're talking about his Muslim and Hindu rights. Particular cases, Ahmad versus MMF. And then you get other dependents. Remember I told you sometimes you get a child or a grandchild that can be giving money to the parents or the grandparents. So they can qualify as third parties. Then you get children and the spouse on the death of the one parent, and it also covers adopted children. Other third parties include executors, and this is a specific instance if the deceased was treated at hospital and then died, then the executor in that instance has a locus standi to claim, but for past medical expenses as well as the funeral expenses. And that's mentioned there in your paragraph 8.5 of your guide. It also covers curators, heirs, legatees, owners of vehicles. A supplier, remember I told you like Discovery or a doctor, they are not considered a third party because they are the ones that are suppliers. They are supplying the hospitalization or the services, if I could put it that way. So generally, if you don't have the locus standi, it doesn't invalidate the claim, but the RAF will not pay until this is established. So in a particular instance, let's just say there's a dispute on whether a child is actually a child of the parent and is a dependent, and then you need to prove certain things that the mother is the biological mother or whatever the case may be. Illegitimate children, illegitimate child with no birth certificate. There's cases like that, especially in the rural areas. So in that instance, the RAF actually accepts affidavits from maternal grandparents and other family members. And in that they state that this so-and-so Mrs. X is the biological mother of this particular child, illegitimate child. Foster parents locus standi. So the foster, yeah?
Yes, can I ask the term illegitimate child, was it not declared unconstitutional? I think from family law, I remember.
You are right. You are right. I do remember that as well. I think so. So let's just scrap that. And if it's in the notes, is it in the notes as well still? Okay. If anybody finds it in the notes, let me know, right? But we must actually scrap that from the slide. Thank you for bringing that up. Okay. So I need to scrap
born out of wedlock.
Yeah, you're right. I need to remove that terminology there. Thank you for bringing that up for me. Then you have a foster parent. They do not have the locus standi to claim on behalf of the child. So they can claim, though, in their own right. So that would be in their personal capacity for loss incurred as a result of the custody of the child. And those are the instances of only hospital and medical expenses. So they can only claim for hospital and medical expenses in their personal capacity, right? And if the natural parent cannot be found, you have to appoint a curator. Are you following me still?
Yes, Prof. I would like
Thank
to
you,
check.
Yes,
Prof. In terms of claims for loss of support, specifically for children, do we have age limit?
Yeah. So the general rule is that until the child is self-supporting. Most of the time they will work on an age limit, but the general rule is until the child is self-supporting. Children come from all kinds of different backgrounds. Some might be coming from an affluent family home where they would not be working until the degree is finished. So then they would work on the age when the child is self-supporting. But that's the general rule, until the child is self-supporting. Okay, but we are going to come across that, I think, in another slide. That will be answered. There is sometimes an age group that they do like to use. But that's the general rule, general common law rule. According to common law, Now we are talking, okay, before I start with apportionment of damages, which we have already touched on and you might already understand. But before I get on there, any questions?
Sorry, Prof. I just want to ask something just for interest sake. For the prisoners who got injured while they were maybe in transit, then what happens to them?
I think the road accident fund can apply depending on if the requirements are met, it can apply. Yeah, I think it can apply. Yeah, we might just have to worry about who we're suing and for what. There could be other claims as well besides road accident fund claims. I don't know if we're talking about other damages or whatever, but yeah, I think that in principle, let's say in principle, it can apply.
Okay, no, thank you very much.
Okay, coming to apportionment of damages. So to begin with, though, the Act doesn't apply to innocent victims. So remember the lady who said to me that if you're a passenger and you're not at fault, you should get 100% of your claim. She was absolutely correct. Apportionment will not apply. It doesn't apply to dependents and to children who are under the age of 7. Why? They are DOLA incapax. A child from 7 to 14 is considered culpake incapax until the contrary is proven. And if you also remember, 14 to 18 is presumed to be that they're basically accountable. If you remember, that's from law of delict. The criminal law actually has different age groups. I think if you're under 10, you consider a child still, or an unaccountable child. But for civil law, we are still following this bracket of age group here. Okay, so if a child is under 7 years and let's just say they ran across the street, you cannot hold that child accountable, and no apportionment of damages will apply to that child. So that I'm just giving an example and a scenario. Remember we had the question where I said if I was involved in an accident and the proven damages are 100%, 100,000 Rand, sorry, and the plaintiff in this example here is found to be 20% at fault. So general basic calculations, it can get very complicated, but basic ones at this stage, you basically minus the 20% of the apportionment. So if you're the plaintiff and you were found 20% at fault, let's just say you didn't wear your seatbelt, then instead of getting 100,000 Rand, you get 80,000 Rand because of your portion of apportionment. Following me still?
Yes, Prof.
Yes, Prof.
Now, if
Yes,
a
Prof.
passenger has failed to fasten
Yes,
his
Prof.
or her seatbelt, right? So if a person doesn't wear the seatbelt, they will definitely be found, a portion of negligence will be attributed to them. So now there's a question here. It gets a little bit more complicated, but let's deal with it slowly. Let's use an example. Let's say A doesn't wear his seatbelt and he is injured by the negligent driving of B, right? But now, remember, A is partially at fault because they didn't wear a seatbelt. So if A's damages were 10,000 Rand, that's for the hospital expenses, right? Now the law says, had he worn his seatbelt, his damages would have been only 4,000 Rand, right? But now how we apply apportionment in this case. So let's just say that A was found 50% negligent for not wearing his seatbelt. Then this would mean he would be entitled to the amount that he wants to claim, which is the 10,000 Rand, minus 50% of the 6,000 Rand. So that's just a basic calculation, colleagues. It can get even more complicated than this, but I don't want to complicate it further. But you understand just the basic principle?
Yes, we do.
Yes.
I'm getting lost somewhere.
Are you getting lost with the apportionment?
Yeah.
Yeah. So remember, we are applying apportionment, right? Because you didn't wear your seatbelt. A didn't wear his seatbelt. Now he's 50% negligent. But we don't say 50% of the 10,000, right? We say 50% of the 6,000 because that would have been the damage. In other words, the damage would have been if he hadn't worn his seatbelt. So I just want to give you an example. It gets much more complicated than this, and there's higher figures involved. But basically, you've got to say 10,000 minus 50% of the 6,000. Because had he worn his seatbelt, his damage would have only been 4,000. All right? Okay. Don't get too hung up on it. Don't worry about it too much.
Prof, question here. Does apportionment find application in an unidentified claim or the hit and run?
Yeah, so in the hit and run claim, it can apply actually. I'm trying to think of an instance. Let's just say you were a passenger that didn't wear your seatbelt. In one of the RAF forms that you've got to fill in, you've got to actually state whether you had your seatbelt on or not. And they just like to apply apportionment immediately when then they see you haven't worn your seatbelt, or they've got proof that you haven't worn your seatbelt. They like to just apply that 30% already. So even if it's an unidentified claim, they can still apply the apportionment. So it's just basic principles again.
So, Prof, can we go back to the calculation?
Hello, Prof.
Hello,
Prof. Hello.
Yeah.
If the damage amounts to 10,000.
I'm a little bit lost there, Prof. The apportionment shouldn't be supposed to be on 4,000, not 6,000.
Had A worn his seatbelt, his damage would have been 4,000, which means he's made 6,000 Rand for nothing, right? He's made that 6,000 Rand because of his fault. So that's why we're working on 50,000 of the 6,000 Rand.
Shouldn't the answer be 3,000 instead of 7,000?
Maybe it should be the other way around, Prof.
No, I'm telling
Can
you,
I
this
try
is
to answer, Prof?
This is definitely,
Hey.
yeah. Clarify.
Yeah, no, it's confusing.
Yes, so
serious.
basically this person would, so
Look,
basically
Prof.
what it's saying is
I would
that
be confused.
this person who's A would have been, is claiming 10,000 of hospital damages because they hadn't worn their seatbelt. But had they worn it, the damage would have only been 4,000.
Yes.
So the
So
apportionment
meaning
is
the
applying
6,000.
is his caused
The
by his
difference between it
negligence.
is yes, it's what is caused by his negligence, meaning that you would the apportionment would be based on the 6,000 and not the 4,000.
Exactly. Yeah.
So
But what is the 50%
so what he
of
claimed,
10,000?
It's
What is the 50% of 10,000?
It's 3.
50% of 10,000.
No,
It's
not
5,000.
of 10. Not of 10. You've got to work
not
on
of
the
10,000, of the
Look,
6,000.
look, Prof. How I look at it myself is
I know where you're going. Right. Let me stop you there, colleagues.
all right.
I know exactly where you're going. When I first saw it and I first read it, I also went to Professor Klopper and I said, no, I don't understand this. And he wrote it out in his book and explained it. And he said, this is how it is calculated. So just trust me and take it as it is.
Okay.
Right?
Okay,
Yeah,
Prof.
I know exactly what you're saying. You feel like, why should that apply? But this is how the apportionment applies. And to be honest, it becomes so much more complicated than this, especially when you're dealing with loss of support claims. It becomes even more complicated. But I'm trying to break it down as simple as I can. This was the simplest example.
Now look, Prof. What I need to know on that 50%, the 3,000. Where is another 3,000? Where is it going to that other 3,000?
Because remember, you are 50. You are
And this
remember you
issue
are
needs a lot of
50%.
clarification, Prof. Hey, we'll find this one on the exam.
Okay. No, you're not
this
gonna.
be a
You're
question
not
in our
gonna.
exams?
No.
Guys, we want to understand, guys. We want
Right.
to
So
understand.
listen to me. You're not
I'm
going
worried
to
of
get
the
this
exam.
question in the
lost
exam.
us, Paul.
You're not going to get
Yeah,
an exam
Prof.
question like this, which is complicated, right?
So
I'm
it won't be on the
But we
exam.
need to understand it.
No, not as complicated as this. I think the worst they can ask you is, you had 10,000 Rand damages and you were 50% negligent. What damages, what are you entitled to? Then you're just going to say the 50% of the 10. Yeah, just keep it simple as that. Okay?
Yeah, that's 5,000.
Yeah. Just
But
keep it like that.
Prof,
Let's forget about all this for now because you're going to get more confused.
but maybe some other time we need to go back to it so that you can understand it for the future.
We
And
need to
also,
understand it.
Yeah.
Exactly.
So remember A is the person that is also at fault. They are the plaintiff that is claiming. They are at fault. So the hospital expenses come up to 10,000 Rand. That is the bill from the hospital. But now
Yes.
A is 50% negligent, right? So what they said is that if A had worn his seatbelt, if he had worn his seatbelt, right, his hospital bill would have been 4,000 Rand and not 10,000 Rand.
Yes.
Right? So what happens now? That 6,000 Rand is an extra expense which shouldn't have been there, because if he wore his seatbelt, he was only going to have 4,000 Rand hospital expenses.
So he should pay for that amount himself.
Yeah, you're
Prof,
right.
Is liable for that. The other amount is liable to pay
For the
it.
6,000.
Prof,
Yeah.
Prof,
Yeah.
listen to this. When you apportion it between A and B, sort of.
Yeah.
Yeah, but now it says that if you wore a seatbelt, you should have claimed 4,000. Now it means that the 6,000
You're not claiming 4,000. Remember, if you had worn your seatbelt, your damages, your hospital bill would have been 4,000.
4,000. That's correct.
So now, are you not supposed to say?
Yeah. So because it's a complicated case, that I'm giving you the basic of the more complicated cases that you get. Now, remember, I said A's damage hospital bill is 10,000. RAF is saying that if he had worn his seatbelt, the damage would have only been 4,000. They've given that as a given, right? Take it as it's a given. So when you're apportioning, because now we are applying apportionment, because the sticky thing of apportionment came into the picture. So you apply your apportionment not to the 10,000, but you're applying it to the 6,000, because that's the damage that you made extra by yourself, because you didn't wear your seatbelt.
Yes.
So the
now
apportionment
I
is applied to that
understand.
part of it only.
Yes,
It only gets applied to that.
You are going to pay for the extra amount.
Yeah.
No, guys, I
Yeah,
think, Prof, can I attempt? I was
The-
also
my colleague,
confused.
my colleague
Yeah,
is in
so
charge
why are
of
they
doing
calling
the
it
numeracy
50%?
skills assessment.
It's just an
Why is it
example.
called 50%?
Yeah, it's just an example where I'm just giving an example where the court said you found you 50%. It can be different. They can say you were 30%, 70% or whatever. I'm just giving an example, because if we go on other figures, it's going to be more complicated for you. I'm trying to break it down as simple as possible.
Okay, Prof, I think I have an easier way of explaining it. I was also confused. Okay,
Right.
so now
Last
the
chance.
fourth, yes. Okay, so now the 4,000 is accepted. It's fine. Ne? So the question is the 6,000, ne? The balance of the 10,000. So now when they look at everything, maybe the car didn't have a seat belt. So they cannot say you are 100% responsible for the 6,000. You are only responsible for 50%. So that's how the calculation works. I think.
So this is only because you're apportioning. Let's just pretend that this A had worn his seatbelt, or the car didn't have a seatbelt, so it wasn't his fault. Then his damages were 10,000. He would still get 10,000. But because we are talking about apportionment, that's where the problem comes in. And when we apply the apportionment, we only apply to that portion that was caused by his negligence, because that 6,000 Rand is extra he made by himself. So we're apportioning only that bit.
But
Which
how
means
can
A is getting 7,000.
how can 4,000 can be the 50% of 10,000? Isn't it supposed to be 5,000?
So you're saying the 10,000 Rand, which is your total claim of the hospital expenses, right? 10,000 Rand is your total. So now you want to say you are getting 50% now you want to apply your apportionment. So you have to make a separate calculation. And when you apply apportionment, the rule is you only apply apportionment for the damage that was caused by your negligence. And that's the 6,000 Rand. So you're only applying apportionment to the 6,000 because that you caused extra.
Prof, are you saying that A is getting 7,000 Rand?
Yeah.
No,
because it's minus 3, 10 minus 3. Okay, you know what? Let me do this. Let's leave this for now. Let me go back to some other questions, not exam, sorry, because then you're going to get scared. Let me go back to some questions in the study guides or somewhere. And let me find some other ones and let's see if we can do that tomorrow, yeah? Yeah?
That would be helpful.
Okay. And maybe it's my way of explaining. I need to find a better way. But let's get back to that tomorrow. Okay.
Prof, can I just try and understand? Maybe just explain how I understand it.
Okay.
Last
I shall give
choice.
you the last chance, colleagues, and
Last
then
chance.
we've got to leave it. Yeah.
My understanding is that you take you have the 10,000 of medical expenses minus the 4,000, which gives you 6,000. Then your calculation would be 10,000 minus the 50% of the 6,000, which is 3,000, gives you 7,000.
Yes. Yes. So is that maybe what I should have actually put for you
Yes.
guys there? Should I
Yes.
actually written the 3,000 Rand for you so
Yeah.
that you would understand that it's 10,000 Rand minus half of 6,000, which is 3,000. So in other words, it's 10,000 minus 3,000. Yeah.
3,000.
Yeah.
7,000.
Okay. Okay. Let's
We're
going to come back to that.
Prof.
You know what we're going to do? First thing tomorrow. First thing tomorrow, we're going to work on another example, right?
Yeah, you used method, Prof. It was hard
Lawyers
to
are not
grasp.
good with calculation.
Yeah, okay, let's get back to that another time. We're getting hung up on something that's really not necessary. Even in practice, you will have people doing these calculations for you. But I just I needed to explain how apportionment applies. We'll get back to that. I'm going to find another way, right? We'll do that first thing tomorrow.
Thank you.
But before I just want to deal with 2 slides here quickly before we close. So magistrates court and high court practice. Remember, I told you that they will be applicable. There's different rules that apply. It is possible to join things. There's a possible to bring joinders. And remember earlier, we had a nice conversation about how you separate merits and quantum. So that's also possible. There's a uniform rule of High Court 41A. That's in paragraph 4 of your notes. The plaintiff with the summons must serve the notice indicating, so basically it deals with mediation, right? Uniform rule of High Court 41A deals with mediation. So they came out with this new thing that before we just start trials, we need to have some kind of mediation going on. So sometimes you have to actually have an appointment, you try and ask whether mediation is possible. It's different from stating what you agree and not agree on. Mediation is really whether you can come to some kind of agreement. So in that, the plaintiff must state, now the new rule is that the plaintiff with the summons must also serve a notice where they indicate if they agree or oppose mediation. So in that summons, they must serve an additional notice. Now the defendant, when they're replying, or the defendant's plea in return, they must also serve a notice on whether they agree or oppose this mediation. And important, they must also state the reasons. If they're disputing why they can mediate or not, they must actually provide the reasons there. Where parties agree to that mediation, it must actually take place, and they must provide a joint minute where they state what is their mutual decision, what they've agreed upon between themselves. And if the dispute is resolved, then the settlement agreement must be drafted, and that's normally the end of the process there. Then you get interim payments. Okay, let me finish with interim payments, colleagues, and then we deal with that apportionment story tomorrow and damages. Okay, so interim payments and undertaking. So what happens is sometimes the RAF, you don't actually know what is the future medical expenses because the person might need treatment and they don't know the full extent of the treatment still to come. So instead of paying like 300,000 Rand for future things, they might say, we're going to give an undertaking now. And in this undertaking, it's a piece of paper where they say, I undertake to pay for such and such treatment for the spinal injury or whatever in the future. And then as and when those bills come, then the RF pays. So they can do an undertaking. And then there's also interim payments. So interim payments is where they don't pay the full amount at one go. My voice is now going. It's paragraph 5.9. They will look at past medical costs and loss of earnings, and provided that they will only do these interim payments and undertakings straight away if the RAF concedes liability. So in other words, they said, yes, our driver or our wrongdoer driver is 100% negligent. So we agree to that. In the interim, we can pay this, or we can undertake to pay future medical costs. Should the RF refuse or fail, then the Rule 34A kicks in. Remember, I said undertakings applies mainly to future medical expenses, and in that document, they can state their apportionment that applies. So they can say that we are liable for only 60% of this person's damages for the spinal injury. Right. There are caps that applies to loss of earnings, and that we will deal with tomorrow when we deal with damages. So we'll start with damages tomorrow. Colleagues, are you okay?
We're moving right along.
Yes.
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 Yeah, okay, Prof.
Yes, Prof.
Okay,
Yes,
so
we
we were
Prof.
we're
What
supposed to
time
end.
tomorrow
Yes, we are
morning?
still pretty much high.
So tomorrow it starts again 5:30. Tomorrow we have to
All right,
finish.
Prof.
Oh, I
Okay.
thought in the morning. Okay.
Okay, Prof.
Yeah.
Prof.
Thank you.
Okay.
Bye.
Okay, colleagues.
you.
Okay.
Good
Thank
night.
you.
Okay, I'm gonna go and research that question for
Thank you. Good night,
All
Prof.
right.
Good night.
Okay, colleagues. See you tomorrow. Bye.
Bye.
Okay, bye. Bye.
Bye.
Bye.